covered by this judgment. But this is not covered by this judgment, my lord. This judgment is with regard to the standard operating procedure, how the leaseholders will operate, my lord. But this is a PIL with regard to that illegal lifting of mining, my lord. Minor mineral, that is sand, my lord. So that judgment is not applicable to this case, my lord. On that basis, your lordship had disposed of the matter. I had filed a recall order. Thereafter, your lordship said that no review file. I filed a review. That is why the delay is there for 10 days, my lord.
No, but this decision,
My lord.
according to you, Prasant Kumar Das is not applicable,
Yes, my lord.
right?
My lord, this case is with regard to the leaseholder. The leaseholder who had, my lord, there were some irregularities were there by the leaseholders.
This
This,
Prasant Kumar Das.
yes, this court has standard operating procedure has been laid down, and the timing between which they will leave this and how will they leave this is with regard to that only, my lord. But my case is a PIL by some, my lord, unauthorized persons who are lifting sands, and I have given all the details of the photographs and it, my lord, GI with location photographs, how they are lifting the land. I have given several representations to the, my lord's district administration, but they have remained silent. That is my case, my lord.
Yes.
My lord, that will take care of the illegal mining, my lord, because the authority has to follow the procedure laid down by your lordship.
Yeah, see, he submits that Prasant Kumar Das relates to such cases where leases have been granted.
My lord,
He says that here
my lord,
no lease has been granted and the minerals are being excavated without any
My lord.
authority.
my lord.
So without any lease, it's a case of theft. And you are not taking any action. This is the grievance of the petitioner.
My lord, I will file a counter affidavit.
Mr. Mahanti,
My,
please come to page 16. Please come to page 16.
16. My lord.
This representation. There, some plot numbers have been
My lord. He has mentioned some plot, my lord.
described.
My lord.
I think Mr. Pal is making out a case now,
My lord.
saying that these plot numbers have never been leased out. But simultaneously excavation is going on and sand is being transported.
Yes,
That
my
is your
lord.
case.
Yes, yes, my lord.
But at that time, you didn't oppose that. Mr. Devakanda Mahanti was.
Yes,
appearing.
Devkan, but
And
I had not
and-
seen that judgment. He's all of a sudden that this is covered by that judgment.
All right. File your affidavit.
My lord.
Delay. IN motion, so delay in filing the present review application. Let a counter affidavit be filed on behalf of the opposite parties.
My lord.
Opposite party. State of who are opposite parties, all the opposite parties.
All are the state agents.
All that stated so.
4 weeks.
My lord.
First off, the court expects that the opposite parties shall look into the grievances raised by the petitioner in the present public interest litigation. If they are found to be genuine, comma in the meanwhile, full stop.
The date may fix.
Date.
With my lord permission, may I mention?
My lordship, pardon to make a mention, my lordship.
Please give your steps.
My lord, my lord permission, may I mention Admiralty Appeal number 1 of 2024, my lord.
Can you ask your junior to give the slip?
My lord, if it can be listed on Friday, my lord, there is urgency in the matter.
No. If your matter is urgent, the matter may be listed tomorrow.
I'm requesting for Friday, my lord, because there's a person.
The practice is that we go through each and every,
No, I appreciate, my lord.
and if urgency is disclosed, the matters are listed.
Mr.
So if
Kaushik,
the-
Please, my lord.
can't be listed on Friday. This bench does not function on Friday.
Lord, I need before, maybe on Thursday, not Thursday, Friday, I need, my lord.
It depends,
Please.
the nature of urgency, Mr.
Please. Lord, sale of ship has been ordered, my lord, by the single judge, sitting in
We will see, Mr.
the.
Kaur.
Please,
We will
please, okay.
Because I am mentioning from within the list, my lordship, with your lordship's permission. Item 66. I was declared the L1. My case was recommended for approval. It was cancelled without assigning any reason. Counter affidavit is filed assigning another reason. Now they have awarded the work without floating a tender to the entity. It become infructuous, it's not taken up, and I'm informed that your lordships are heavily burdened today. Your lordships were taking up 4 matters at 2 p.m. So 4 p.m. if your lordships can take up, or at best tomorrow under the
4:30?
specifically adjourned list.
4:30 your matter can be taken up.
Obliged.
All right.
Item 66.
You make a mention tomorrow in the morning.
Tomorrow in the morning, please.
My
And please
lords,
inform the other side also.
It's state, my lords.
Even
State.
then, state, so many council appear for.
My friend is there, he's appearing.
Please, I'm making a mention tomorrow, please ensure that if the court decides to take up your matter, then he is present.
My lords.
All right, not today.
Your lordships, I'm making a tougher request.
Yes.
Item 60, it's that mining matter. In fact, your lordships have fixed the date today and had asked me to make a mention in the morning hours. So I'm making a mention, it can be taken up at 2 p.m. But
Nothing
now-
is tough for us.
Yes, I know, your lordship, it's tougher request I'm making, but your lordship, the only thing is.
For
because-
you, your request, all right.
No,
When
it's
you
tough on
understand,
bench
then,
also.
all right, we will try.
Lordships.
My lord, item 72. That is a admission matter, my lord. I have filed the amendment petition for amendment of the writ application.
Which matter?
72, my lord. My lord, admission matter, why handicapped girl is to be admitted.
Change of institution.
Yes, my lord, synergy and others. 72, I have filed petition for amendment of the writ application. 2 things are there. I have incorporated in the amendment.
No, amendment is not urgent. Your cause may be urgent.
My lord, unless it is amended, I cannot pray before my lord for amendment for a hearing of the matter.
No, the fact that you have brought something on record, new material on record, and that makes the matter urgent, we can take up.
Pardon?
Amendment for what?
Amendment because AICT, All India Institute of Technical Education, has
Council amendment in the pleading.
Of the cause title.
The cause title.
Cause title.
amendment by pleading party is.
my
You
lord.
say that AICT has to be added.
Yes, my lord.
Simple as that.
Yes, AICT is to be added.
Only that.
And another, I have represented to the Synergy Institute that 2 copies have been filed also. That was not in the
That you're
original.
adding.
So many.
my lords,
Who is AICT? Who appears for AICT?
Satpathy. Who appears for AICT?
Central government, government council,
No. AICT.
central government council.
First of all, inquire, otherwise we will have to issue notice.
Other notice will have to go inquire so that you can hand over a copy also.
Yes, yes.
my lords, may I be kindly allowed to mention 2 new cases?
Give a slip. Do you have a slip?
Yes, sir.
Give it.
My lord, item 73, my lord, pertains to NEET admission matter, may be taken up today, my lord.
We will try.
My lord.
Item?
We cannot do something
73,
which
my
is-
lord.
Yes, we are looking
This
for
is-
you on Thursday. You are not there. At 2:30 before those matters were taken up, we are asking if any urgent matters were there. You are not there. Anyway,
Admission to what? Oh, that,
this is what admission?
My lord, revaluation of,
That 2 marks, 2 questions.
my lord,
We'll try.
obliged.
Yes.
Item number 1,
Weekly daily. Weekly daily.
matter which your lordship has.
Yes.
As directed by your lordship, we have given that affidavit. We indicated therein that the proposal that we had given, that is the final one, we cannot make any concession thereof. Because all these lands, my lord, these are owned by the state government. The state government leases out land to us for industrial purpose. We develop the land and then give a sublease for a particular period. So it's not within our domain to sell away the land. The only thing that we can do is grant a lease.
That is what,
For a specific
that is
purpose.
what I precisely say, that whatever the guidelines they prescribe, under those guidelines, whatever the price is, I'm prepared to pay. But they are saying, first of all, in their previous affidavit, your lordship remembers that they had given a price of a different plot. Lordship remembers that I gave the affidavit, reply affidavit, saying that this is the plot, this is the benchmark valuation as per the lordship's direction. But they have a set of guidelines under which they have fixed. I have not fixed that. That's why last time if your lordship remember that I had submitted that if they now go to give it to X or Y or Z, they have to follow their own guidelines. This is not a private sale. They can sell it at any price. So therefore, Lord, I say that I am prepared to take it on that, and they are sticking to that previous, which they had given before your lordship.
And we will have to decide it, no?
Yes, Lord. Lordship may decide.
No, here it is there.
Just for
No affidavit. Mr.
Just for a
Mukherjee,
moment,
Yes, ma'am.
just for a moment, for your lord, if your lordship just kindly see their own document. They have fixed the price. I have not fixed. That reply affidavit which I had given, dated 36/20/2024, where I have annexed at page 17, annexure 19. Running page 137. 137.
This 44 crore 60 lakh is what?
For 2 acres of land.
For
2 acres of land.
what is it?
That is the benchmark value which we have claimed as undertaken by the petitioner before your lordship, which has been recorded in your lordship's order.
Benchmark value for what?
Value for the land.
What? I mean, what way will you
so
give?
if we
We'll give by way of lease for the construction of a hotel, which
So,
the,
the lease value is 44 lakhs.
yes, 44 crores, yes.
44 crore.
No.
and not the value of the land.
No. Land value, there, my lord, the market rate today for this particular land would be about 100 crores.
No.
That would be the market value.
Because it's a huge.
2 acres, my lord.
With
2 acres
just
of land in Vocational Municipal Corporation.
I have given the government valuation as well as their own valuation. I have given the government valuation.
Benchmark valuation does not
Just-
reflect the
just-
market rate.
Just where you are You want to show us which document?
No, page 137. 137. Lordships kindly sees that that is their own calculation. I am not making. Annexure 19. Lordship got it?
Annexure 19 to what?
Of the reply affidavit dated 30th of June 2024 at page 137 of your Lordship. Lorships are not getting.
Just a minute.
Page name. So 137 is part of what?
Part of the reply affidavit filed by the petitioner. That is dated 30th of June 2024.
Dated 30th June.
30th of June 2024. Internal page 17 of that affidavit.
Yes, it is there. Annexure 19.
19.
Yes.
Lordships, what kindly see, in pursuance to the decision of the board of directors of Ex-Cadre taken and so held in meeting and so, the land cost in respect of the following industrial estates areas in the state of Odisha has been fixed as follows. Item number 2 is Manchester 150 lakhs. And I have given their guidelines how they fix. My learned friend is right.
Manchester. Is this Manchester or what?
Yes, this is Manchester. But they have fixed, and they have fixed not by themselves.
2019.
And 5 years.
2019.
Yes, 5 years, 19. Your Lordship may increase it, let us say 10%, 20%, 50%, whatever it is.
No, but what is the meaning of this cost of the land?
Cost of the land for the purpose of lease, as my learned friend is, I have given the guidelines. Your Lordship will see that just previous annexure, just the previous annexure, if Lordship kindly sees. That is at page 10 of that affidavit. Lordship got it. A lease is a contractual arrangement calling for the lessee user to pay the lessor for use of an asset. And this is a lease for 99 years. It's not an absolute sale. And this is fixed on the basis of the market value, benchmark value. That is, your Lordship will find at page 69.
Yes. Yes. So what is the basis of your calculation? This amount of 44 lakh?
I have given that
No.
government.
We are asking him.
Mr. Mukherjee, what
Yes,
is the
madam.
basis for calculation of this amount? 44
Crores.
crores? Yes.
Yes, madam. That is based on the basis of, I have given an affidavit.
Page 6 of his affidavit.
Your Lordship will take page 7 of my affidavit dated 26/6/24.
It is there.
Yes, madam.
What is the basis?
The area benchmark value is so and so. Unit wise per acre it is 22 crores 40
Who has
lakhs.
fixed this benchmark?
Sorry, my lord.
Benchmark, how have you arrived at this?
It is the
benchmark
state
value?
government. It's the state government fixes a benchmark. Now, what has happened is, my lord, this area, Chandrasekharpur area, it comprises of industrial plot, it comprises of commercial plot, it also comprises of residential plots. Now, this particular plot has been earmarked as a residential, Ghorabari, for house site. The plot in question, my lords. Now, since it is, and he is take it for a commercial purpose, we have taken the benchmark value of the nearest in the same moja. In the same moja, the nearest plots, commercial value, commercial plots, benchmark value, which is 22
Again,
crores
we are
40.
trying to understand,
Yes, Bhagat.
how have you arrived at this benchmark value?
That is provided by the state government.
Where is that?
Yes.
I have given.
This is, my lords, the state government's document. This is downloaded from the state government IGR. Your lordship sees Inspector General of Registration, Odisha, Cuttack. This is the rate provided by them.
Where is that?
That at page 7 of that affidavit, which I was showing to your lordship at the bottom, at the middle of the page, after the figures, this has been issued by the IGR. That is an officer competent to fix the
Again, this
benchmark value.
benchmark value is for sale or lease?
But a benchmark value is for conveyance of the property.
Conveyance of the property.
Conveyance of the property, my lords, the Bhubaneswar, my lords, if your lordship.
You are making him to pay the, asking him to pay the value of the land.
Yes.
As per the rate, as per the benchmark decided by the state government for grant of lease.
Yes, my lord. That is what, because there is no benchmark for lease as such by the state government.
Absolutely right.
Now, he had made a submission before your lordship because his lease stood terminated for reasons which I can place before your lordship. There is no lease subsisting as of now. Now, today, my lords, if he were to again consider, he has to make a fresh application. It will be as per the norms which are prevailing today. Now, to cut short all this controversy, he made a submission before your lordship that I am ready to pay the benchmark value, which is recorded in your lordship's order.
Mr. Mukherjee, even if he's prepared to pay the benchmark value, he must have made it on the presumption that you will sell the land, because your lease will have to be
Well, I
calculated
cannot
on
sell-
base.
I
So,
cannot
all right. So you will calculate what will be the lease value based on the benchmark.
That, my lords,
That is
there
provided
is
in your meeting, those minutes.
no, there is no mechanism, my lords.
It is there, it is there.
It is not there, my
That
lords.
document filed by him, I think, if I'm not
No, my lords,
mistaken.
that, my lords, that is for a fresh lease, which is fresh lease.
But
when
aren't
it-
you giving him fresh lease?
No, my lords, what, this is a case, my lords, which is
No, we have
different.
understood. It was cancelled earlier.
It was cancelled not once, but twice.
Okay, okay. If you give it to him as a fresh lease, you'll calculate the amount.
Yes, my
And
lords.
for the period he has held it, you can charge him for that period also. Because it
My
has,
lords, if you were to charge that penalty, it would be more than that. It would be more than 44 crores that we are now asking for the occupation of the land for this period from 99 till 2024, 25 years.
and another thing, you said that is the value for homestead.
My lords, your lordship knows. Yes, yes.
Does IDCO give land for homestead?
No, it is
Doesn't.
there. The document which my learned friend just referred to, the lease is granted of homestead and agricultural purpose. There are certain lands which are also given for homestead purpose, because in Rourkela, there are lands which are leased out where the person can live and also have his industrial purpose. So both the dual purposes are served.
Or a farm and maybe stay there also,
Yes,
agricultural
yes,
and
yes,
homestead.
ma'am. That is the purpose.
This is not the case like that. This is purely industrial.
Other people will stay there if you make build a hotel.
But I have given the government document which your lordships are asking, where the government has fixed the price.
Where is that located?
That is page 6 of my affidavit, which your lordship was saying. Annexure 17. This is the plot number, Mauja, everything has been used.
Well, it's in Bhubaneswar today, 80% of the land are leasehold, either granted in lease by GA department or the BDA or the housing board. These are all leasehold lands. There are very few parcels of property which are freehold. Now, my lords, government has started a step by which they are converting the leaseholds to freeholds on payment of premium.
Yes, Mr.
But your lordship sees that their guidelines I've given, it is titled as procedure for lease
No,
of
that's
government
not- see.
for industrial.
See, we were trying to make both of you negotiate
Yes.
and come to terms.
Right.
That has failed. Now the question is that we have to determine your rights
On the basis of merit of my case.
on the basis of
Merit
so
of
whether
cancellation was correct or not.
cancellation was correct and whether you have any right or not. That we will decide now. That we will decide.
I'm ready.
Because we have.
I'm ready.
You can address.
Your lordship today, your lordship can see. But your lordship sees annexure 1 first at page 21. That is the grant in my favor. Pursuant to your petition, ITCO plot measuring 2 acres and corresponding to revenue plot so and so. The plot is allotted on leasehold basis for a period of 90 years. Clause 1.
Annexure 1.
Annexure 1. The plot is allotted on leasehold basis for a period of 90 years. They had fixed.
No, annexure 1 by 1 or annexure 1?
1, page 21.
21, yes.
Page 21. The plot is, clause 1, the plot is allotted on leasehold basis for a period of 90 years.
Yes.
Right, sir? But now, your lordship sees, this is the grant which was given to me. Now kindly come to the impugned cancellation at page 64.
Yes.
Sugar. Please refer to this office letter number so and so, that is annexure 11, the show cause notice which they had given before cancellation. Regarding breach of terms of allotment of plot number so and so made in your favor. We have received your reply in response to your show cause notice and the reply is not satisfactory. You have violated the terms of allotment undertaking agreement of plot number 8 on following grounds. Reason is you have not utilized the plot for the purpose for which it was allotted since long, thereby violating clause 16 of the allotment letter dated 23/4/99. This is annexure 1, 23/4. Kindly see clause 16. At page 23. Sorry. Yes, page 23. If your lordship. Lordship got?
Yes.
You will have to start civil construction on the allotted plot within 6 months and utilize the plot and start commercial production within 2 years from the date of possession. It is not that to complete the construction, you have to start within 6 months and do it.
Oh, no. It says you will have to start civil construction and
within 6 months.
Utilize the plot and start commercial production. Commercial production means
within 2 years from the taking over possession.
Yes.
So that your lordship may kindly mark. But now your lordship may kindly see the date chart which I have given. There your lordship will see this allotment was 23/4/99, annexure 1, your lordship sees, in which the clause was there, and in the impugned order they say supposedly I had violated this clause 16. On 11/1/2000, possession was handed over. Right, sir. Then 31/10/2002, the allotment was cancelled. Allotment was cancelled on 30. Then this eviction case started against me. In the eviction case, a quasi-judicial statutory authority had passed the order to make me construction. That is at page 27. Lordship may kindly see.
No, but please come to this, come to list of dates. 18/1/2006. You are referring to which you want to refer to which document?
That is page 27.
Annexure?
Annexure 2.
Annexure 2, yes?
Yes, Lord. This is, Your Lordship kindly recollects that after cancellation, they started an eviction proceeding. In the eviction proceeding, this order was passed in presence of those parties. The case is taken up today. The representative of opposite party is present and filed show cause. They have explained that the super cyclone had affected tourism industry. As a result, they would not go ahead with the project. Now, as it appears, they have already started construction and construction materials have already been dumped on the field. In such view of the matter, and the willingness and the assurance that they have put forward by the representative of opposition, the court hereby directs the divisional head IDCO to allow them to go ahead with construction work. Further, the OP is directed to clear the outstanding statute dues within 15 days. And this was done. This was done and this construction was started and all outstanding dues admittedly till date have been paid. There is no outstanding against them. But thereafter, there is a clause in this, after this order was passed and after this was complied with, they revoked the first cancellation. That Your Lordship may kindly pass. They revoked, that is Annexure 5 at page 34. They revoked the first cancellation.
No, but what is this? 18/1/2006, you were directed to amend the plans?
Yes. Amend the plan, I amended the plan.
You take 2 years to amend your plans.
No. 24 drawings, 28/9/8/2004, drawings and plans submitted to IDCO for approval.
Please, Annexure 3, we are referring this thing to your list of dates.
Yes, Lord.
18/1/2006, the IDCO directs you to amend the plans of the project and
Yes,
adhere with the IDCO guidelines.
Yes, Lord.
So it took you 2 years to amend.
No, they have to give the approval.
No. See, you amended. Please see Annexure 3 and Annexure 3/1.
3. Annexure 3.
Please come to list of dates.
Yes, Lord. I'm on the list of dates. You said 9/8/2004, Your Lordship.
18/1/2004.
I have seen. IDCO after 2 years directed amendments in the plan. IDCO directed.
Yes, IDCO directed you to amend the plans.
Yes.
And why the direction was issued? That to adhere with the IDCO guidelines. This is what you have stated.
Yes, Lord. To adhere to the IDCO guidelines.
Adhere to the IDCO guidelines. This is what is mentioned in your list of dates. And now you take 2 years to amend the plan.
No, amend the plan, they stated, and thereafter I amended the plan.
2 years.
No, we have not. We have submitted necessary documents. Oh, that Your Lordship, with the BDA. That is with the BDA for requisite plan.
The question is that you were asked by the IDCO to amend your plans and adhere to the guidelines issued by the IDCO.
I adhered to it.
Adhere to you?
2 years. Yes, bro. Your Lordship is.
Then you are not interested. You are
No,
just.
Lord. No, Lord. Thereafter, that was condoned. That was condoned. And revocation was made.
There is no question of condonation. We are in writ jurisdiction.
Lord,
we have to see your
I'm
conduct
coming to it,
also.
Lord. Thereafter, lease deed was executed. Thereafter, the revocation was withdrawn. Lease deed was executed.
Right.
So, therefore, a fresh cause of action arose after the lease deed. Because everything, I showed that decision, Your Lordship, that day, it is there, that after execution of the lease deed, the earlier covenants and all the terms and conditions, they recede to the
So, what is the date of lease deed?
Lease deed is item 14, 7/12/2010.
Yes.
Now, this lease deed, here starts, the cause of action starts here. But on 2010, when the lease deed was executed, a fresh cause of action arose and fresh covenants were entered into between the parties. Clause 5 at page 38 says this. Your Lordship may see that. That is what has been the difficulty. Page 38, clause 5. Notwithstanding anything contained in the lease deed, the lessee with the previous consent in writing of the lessor can assign or transfer his interest in the property in favor of the scheduled bank, financial institution, insurance corporation.
Which clause you are reading?
5.
Yes.
Notwithstanding anything contained in the lease deed, the lessee with the previous consent in writing of the lessor can assign or transfer his interest in the property in favor of the scheduled bank, financial institution, life insurance corporation, or any other bona fide source of securing loan to be advanced by them for purchase of machinery and raw materials, etc. Provided further that the lease for the purpose of constructing building on the demised basis seeks to obtain loan from bank or other financial institution by mortgaging leasehold interest on the demised premises in favor of such bank. Permission of the lessor shall be deemed to have been given subject to conditions. But this, accordingly, I applied to the banks. The bank gave a condition at page 56. That is at page 56. They wrote to ITCO. Your Lordship got that.
Yes.
Page 56. We have received proposal from petitioner for financing their hotel, which is coming in plot number so and so, has proposed to mortgage the land in said plot with hotel and other infrastructure of the hotel will be built. Our bank is processing the loan proposal for the hotel project. In this connection, Punjab National Bank will require a no objection certificate from Odisha Industrial Development Corporation for mortgaging the land over which TK International will be constructing the hotel and infrastructure. Therefore, please accord NOC for creation of mortgage so that mortgage can be created over this land. Here the trouble starts. The moment they sent it directly to the ITCO. ITCO forwarded the same to the divisional head. That is Annex 10. Sorry, page 59. Page 59. On the caption subject, it is to intimate that the above-mentioned unit has applied for issue of NOC to avail financial assistance from Punjab National Bank. The application of the unit along with other requirements and equal is used for information and necessary action. All these. Copy forwarded to so-and-so for obtaining approval from government. But this is 15/5/2013. But no reply was given to this. No action was taken on this. But straight away, the show cause notice was issued on 21/6/2013. That is Annex 11. That is within a month.
This shows that you are incapable. You cannot do it.
No. I can take loan from.
No, now you cannot, because everything shows that you just participated in the process, got the lease deed executed, and beyond that you are not able to get your loan sanctioned.
No loan, because the bank is giving the condition.
The bank gave the condition. The bank sought for the NOC.
Yes.
The NOC could not be issued.
No, NOC is they will give.
You are right. You are right. Please don't compel us to say something which we should not say. But the fact remains that you did not get the NOC. Could not get the NOC for the purpose of. So even if you attempt today, you cannot do it because they will again sit over the matter.
No, they will sit over the matter, but instead of they could have rejected. I can say that
the petitioner must realize that we cannot start.
They could have rejected this and said that show cause. But they straight away issued the show cause.
We will see the affidavit. We will see the pleadings. Counsel appearing on behalf of the senior counsel, and then counsel representing the senior counsel representing the ITCO. The judgment is reserved. So 1 week time is allowed for the parties to file their written notes of argument.
Item number 2.
WPC number 18918 of 2022 in that batch of cases. But in that case, on last occasion, I filed an additional affidavit where I have stated that similar benefit has been extended to the Ganasithyaks and they have been treated as within the elementary cadre. But that affidavit has not come.
Let that come.
Yes.
When did you file it?
Well, it was
For filing that, I think
11
you had
9.
given four dates.
Well, 11 9
Last time it was given
2024.
last year, sir.
11/9.
11 9 2024.
Very good. It is WPC number, so it is stated by learned counsel that one additional affidavit has been filed on 11
11 9 2024.
11/9/2020 online.
No, in the court.
Most of these said
The
affidavit
court's
is-
here.
CPG. The
So in the
said affidavit-
registry.
Kindly see that.
the said affidavit is not there on.
Not in the court, in the registry.
Is this matter on 2 weeks? Yes.
Item number 3.
Note on the last bit, your lordship wanted to know this. That what is the methodology for getting this clearance?
Yes. I'm sorry to interrupt. Some time may be granted because I have called the officers to discuss. It's a case of lapsation. So at least 4 weeks time may be granted. We'll file an affidavit.
No, you will have to address that issue. There are two things. One, that the Pollution Control Board is taking undue this thing, time to, and because of the process there, the environment clearance is, in most of the cases, they are getting delayed.
Right.
So we have to balance two aspects.
Right.
One, optimal utilization of your natural resources, and two, the environment.
Absolutely.
All right.
Right.
So if the process of EC clearance is not expedited,
Correct.
then that will adversely affect the utilization of your mineral resources. And if we allow mineral resources to be indiscriminately utilized or taken out, then that may affect the environment. But there has to be a balance.
Absolutely.
So you will have to lay, or you or we will have to lay down a guideline.
Right.
And once the matter goes to you, the Pollution Control Board or whichever authority, they should expedite that. And then this aspect also shall be taken into.
Let's have brought it.
Now, the submission which he is making, that in his case, because you are seeking adjournment and you need to address us on that point, he is saying that it's not a case of lapsing.
Right.
He is saying that something will lapse if something is there.
Got
Right.
Got
If something is not there, there is no question of lapsing. And according to him, we are yet to examine that aspect. According to him, by operation of which section is that? By operation of that section.
4A4.
You are required to issue press office. These agreements are to be executed.
8A3 minute for the balance period.
All right, for the balance period. And unless that is there is no lease. So if there is no lease, then there is no lapsing. So this is what he has.
He is arguing.
So just whenever you want to just address that.
I will address.
There are two aspects. And
I've got it.
that first aspect which we disclosed, that shall apply in each and every case. We will have to be very strict on that.
Right.
That because of delay there, your resources are not properly utilized. Natural resources are not properly utilized. So
Let I will examine these two aspects. I will discuss.
Whenever
4 weeks for
These two aspects I will examine and discuss with you.
Yes, yes, sir.
Whatever date your lordship may have.
And what is the, what happened in the meanwhile?
Meanwhile,
Meanwhile,
Lords, the
I heard
Lord, what has
Meanwhile, in
happened
fact,
is,
last time,
Lord, after your lordships are right, the
it is stated by learned counsel
Yes.
representing the so and so that boards have submitted its report.
board has submitted its report. We have made our compliance. Now it is with the SCIAA.
Again, a state agency or?
Yes,
yes, that's it.
and that there's a time limit of 60 days for that, which will expire sometime October 22nd
So
October.
what is the relief which you are seeking in this?
Lord, ultimately what I'm saying is that my lease, the lordships will give me a status quo or say it will be subject to
No, no,
reservation.
we'll not, there is no question of status quo.
That's all right. So all that I'm saying today, your lordship wanted to know the procedure. The learned advocate general says that 4 weeks time. The lordship may fix a date.
Yes. As requested by Mr. Acharya and Advocate General. List this matter on 4 weeks, retaining its position, for him to address on the point of the issue of lapsing also is involved.
Yes, yes.
The
It
point
is already
of-
lapsed.
Huh?
It has already lapsed. So he is not permitted
But
to.
we were
take
here
it up.
before your lordship before that.
All right, we'll see.
Let it be after
The
vacation so
legal
that.
legal issues involved in the present matter.
My
All
lord.
right.
And if my learned friend files a counter, even better by that.
That I
You
will
do it.
find. That
It
we
is
have to find.
expected that
That is fine.
in the meanwhile, counter affidavit shall be filed.
And the process shall continue. Whatever process is continuing.
Process
No, that is obvious. It doesn't, that process has.
4 weeks.
Grateful.
Item number 4.
Item 4, your lordship, I have prepared a memo, your lordship, indicating the deficiencies and the inspection report details, your lordship. Admittedly, your lordship, there are deficiencies, your lordship, which are not in accordance to the DGT guidelines, be it infrastructural or be it the workshops or the IT lab in different heads, your lordship. So, your lordship, what I suggest without recording my name for that, let them approach the authorities, your lordship, and may fix a date and time, your lordship. Let them approach them and give in the documents and fill in the lacunas, your lordship, and they can take admission because it is still 39. The date has been, last date has been extended, your lordship, to 30th of September.
See, while you have cancelled, they have cancelled.
No, they had disallowed us by.
They have
Yes.
disallowed.
Yes, your
So
lordship.
which power have you exercised?
Your lordship, the history is that since it was initially an inspection for the scholarship, your lordship, of the central government. There, they found out that there were a lot of 418 institutes were inspected, your lordship.
Yes.
Out of which, your lordship, some of the institutes, they didn't fulfill the criteria. So the director of DAT, they found that it is pertinent that it was on their part that they should intimate them that there are lacunas and they should fulfill them.
So
On 3rd of July, they were called, your lordship. The Stoker's
they
notice
were
was
granted
issued.
recognition.
Yes, your lordship.
They were earlier granted recognition.
Yes, Your Lordship, they
Earlier
were
you
granted. They
recognition
were granted, Your Lordship.
and subsequently you disallowed.
Disallowed, Your
Alright.
Lordship.
So while granting recognition, you must have inspected the institution.
Yes, Your Lordship, that was long ago, Your Lordship. This is the present
Long ago
situation.
means how long?
That have to take
Because they were
instructions.
granted recognition for this 2024, 2025. All right.
Yes, sir. No, Your Lordship, this was earlier to that, in the month of December, last year, Your Lordship.
All right.
Yes.
Last year, but for not for 2024, 25.
No, Your Lordship.
2024, 25 recognition was not granted.
No, Your Lordship. These are permanent recognitions, Your Lordship, that were
These
granted.
are permanent.
But from time to time, as per the norms that have been amended, Your Lordship, they were supposed to upgrade their institutions, Your Lordship.
So, very good. So for 2023, 24, they were fulfilling the criteria.
That we assume, Your
And
Lordship.
24, 25, they are not fulfilling.
Some of the, out of 418,
there might be tables and benches in the classrooms which
No, Your
must have been
Lordship,
taken out for the subsequent 2024-25 session.
No approved building plan layout.
Yes,
That must not have been there from the very beginning.
Yes, Your Lordship, but these are all DGT guidelines. They are all functioning under the DGT guidelines, Your Lordship. They are the ones who made the inspection, Your Lordship.
Is it
After they
your
came
case-
up, after the show.
Is it your case that the approval itself was contrary to the guidelines for 2023-24?
Your Lordship, what we found out from those initial inspection was that there were some deficiencies. So they were given a show cause, Your Lordship, although we had not disclosed the grounds.
Alright.
I admit that.
That inspection was done for a different purpose.
Yes, Your Lordship.
Just a minute.
Yes.
So had this been done after 1 month, after they had taken admission, you would have disallowed?
No, Your
See,
Lordship.
there must be some system, some must be guidelines, some rules, where is that?
That, Your Lordship, these inspection, actually the inspection, the first inspection was because of the scholarship, uploading of the scholarships, Your Lordship. But the director thought it prudent that since there were deficiencies there, some of the institutions
Did you tell these institutions that they are going to disallow?
Yes, Your Lordship, on 3rd of July. 3rd of July.
3rd of July?
3rd of July, we gave them a show cause, Your Lordship. By 9th,
So stating what? That what are you told them what are the deficiencies?
no, Your Lordship, by 9th they had come, Your Lordship. Those institutions that came by 9th, they were again inspected, Your Lordship, by the DGT regional head, by them and by the institute, Your Lordship. This is the second inspection report, Your Lordship.
High-handedness, madam.
Yes. But Your Lordship, without these infrastructural, what will be the fate of the students, Your Lordship? Let them
Fate of these
fulfill.
students. We can direct for an inquiry into the conduct of your officials.
That if these were the deficiencies, how did you grant initial recognition and approval or whatever? How? There's no building plan layout, there is no three-phase electricity connection. It is not that they had it earlier and later they changed it. So how are they functioning without these? You have allowed them to function.
Even if they were, Your Lordship,
You see, even
most
if
of
they were
the
allowed to function, now they cannot function.
most of the admissions were not taken before the 3-7, Your Lordship. There are some that have been taken after 3-7, Your Lordship. Rest of them, there are a lot of institutes which have not taken any, no students are there also, Your Lordship, among these. Some institutes have, out of 80 seats, only 14 have taken admission after 3-7,
Global
Your Lordship.
ITC lease has expired since 2014.
Yes, Your Lordship.
So for 10 years, that was not a deficiency. Suddenly it became a deficiency. No approved building plan.
So either it's a scam or responsible act.
Drawing hall not
So you-
available. No fire safety measures.
Seek instructions, we may direct for inquiry by an independent agency
Fire safety almost nobody has.
tomorrow. Entire right from grant of recognition. So there are certain, you are referring to certain deficiencies
Yes, Your Lordship.
which were there when the recognition was granted.
That, Your Lordship, I have no instruction on that. But
Yes,
these are the
we should
ones
be
that
going
came
to
up even after the second inspection, Your Lordship.
This is
Yes.
this year.
This year.
We are saying since it is functioning since so
Functioning.
many years, on what basis was it functioning?
Should we go into that, madam?
Student record, staff teaching.
I do find few of the
scholarships.
deficiencies. I
Now,
like
suppose.
bills are
wait,
not
just a minute, just by way of illustration. Like recognition is granted to an institution in 2023. In 2024, during an inspection, it is found that there is no building. All right. So in that case, we will have no other option than to direct for an inquiry by an independent agency, not by the state or some other agencies. You can seek instructions whether.
Your Lordship's
Another thing.
wisdom is something which I cannot surpass. But yes, I do find some deficiencies like machinery bills not found. Now, those are curable.
No, machinery found is all right. If machinery
Bills
is
not
not
found
found,
is-
then
Yes, but bills not found cannot.
yes, you're right.
So these are few things which I find
Machinery bills not found means a lot.
no machinery is there. Bills are not there.
No, machinery, where from did you get that? Some other institution for the purpose of inspection?
No, it's an old institution.
Maybe.
May not have kept the bills in a proper way. I can give that much of.
Old institution, how is it functioning without all these things? And another thing, just look into that. This guidelines which they are trying to inspect now, they may be slightly different from what they said they're being practiced.
Maybe we are giving them this choice, both of them. Both of you, the petitioners and state officials also. We will hear your cases, expedite hearing also. We may grant you relief, we may not grant you relief. If we are totally unsatisfied, then we can direct for an inquiry also. Then they may lead to institution of criminal cases, we don't know. But before we do that, just seek instructions, both of you,
Yes.
whether you are ready or not. For that one.
We'll do.
And you given them this table?
This table, if given.
Yeah,
to us.
you have to give them that. Otherwise, how will they know?
It's there in the counter, Your Lordship. All the, yes, all
Of
the
course,
details
the
are there in the
individual
counter.
counters, I think, of a few cases they gave us counter right now. So maybe we'll just
check.
We'll
It's
look
all in
at
the
those
counters.
counters and we'll.
Yes.
Jointly requested on behalf of the parties, list these matters on when?
Tomorrow.
Day after. Thursday, Your Lordship.
Thursday, yeah, taking up, Thursday. Retaining its position.
Item number 5.
My lord, another two matters are there, 22,409 Suvarna Rekha and 22,415 Radhakrishna RTC. Kindly provide interim order for this. Interim order. Last, actually admission date.
All right.
Are they listed today?
Yes.
They listed? Okay, last two.
Item 5.
Thank you, madam.
May please. Lordship remembers this is regarding that reservation for servicemen in medical.
Item number 5.
Five.
Your Lordship, you are not inclined to pass the interim order and told that let them file count, get them 2 weeks time designated to file counter. Till today.
Your Lordship, we are filing the counter today itself, Your Lordship.
Can it come tomorrow or day after?
As you wish.
As your Lordship wishes, I don't know. Because the counseling is still going on. There is some.
Counseling, it is very difficult for you this year. This year it may be very difficult. Have you taken some stand? What instruction have you received?
Your Lordship,
All right, don't disclose that.
He has to serve a copy of
All
me.
right. All right, as requested on behalf of the
Since your Lordship has expressed it,
opposing
man,
parties,
any day
as
convenient
state
to your
officer,
Lordship.
place this matter on Monday, retaining its position.
Not on Monday, my lord. Monday I am going out.
When?
My lord, I am going to my ashram.
When are you returning?
The same day I will
All right,
return in the
Tuesday
evening.
then.
Evening.
Tuesday. Retaining its position. To enable her to file counter affidavit. She must ensure that a copy of the said counter affidavit is served on learned counsel for the petitioner before it is filed. No, she is going to file.
Today itself.
Let the registry ensure that if counter affidavit is filed, the same is tagged with the brief of space. Yes.
Item number 6.
Wait, my lord. My lord, your lordship will remember that this is regarding that stopping of the mining operation so far as the query is concerned and the query granted for permission.
You had an agreement with NHA.
Yes.
And now you are claiming right of query.
No, I am not coming. But there is a provision that for public purpose, you will make an application. There is a rule, Milan. Let me place the rule. Rule 34, Milan. Of the Odisha minor.
And you are doing nothing for construction of that road. Road is not being constructed.
The road is being constructed.
Because you don't have.
Get the material, how will you make
It has stopped, Milan.
Exactly, that is what we are saying.
Therefore,
yes.
Therefore, was there any assurance given by the
state government,
NHI,
yes,
that you will get?
That is a part of the policy.
No,
that is. Your lordship may kindly have a glance.
That you have to construct this. You have to construct this.
Lordship's kind attention to rule.
Counter, where is the counter?
Lord, we have filed a counter affidavit.
Please keep the counter.
We have filed it, my lord, through e-filing. The hard copy also, my lord, we are just passing on. There are serious allegations. Actually, it's in a forest area. So the basic order which was passed by the deputy divisional forest
Why
official.
did you mention the word allegations?
No, my lord, why am because that's a reserved and prohibited area. The
So,
deputy director.
lease has been granted to them, so allegations against whom?
No, my lord, I'm allegation against the deputy director. Your lordship may kindly have a glance at A/4. DFO is not a party. A/4. That letter is also not under challenge. Second August 2024, the DFO writes to the collector and
You are
district
referring to which
magistrate.
document?
Let A/4 at page 11. This order has not been consciously challenged. He challenges the just a minute. Allow me. Let me address. It's my content.
Please take the
This is my petition. You are making a statement which Bihar's record. I'm not. This is not Bihar's record. I'm referring to.
Keep in mind, Mr. Mohanty, you have been Advocate General. The Advocate General has a right of audience.
Precedence. I don't say it.
Please, we'll give you enough time, adequate time. Yes.
Let annexure A/4. That's the letter of the divisional forest officer addressed to the collector and district magistrate of Jaipur for cancellation of the query permit on the ground that it was illegally granted by the deputy director and it is located in a reserved forest area. Your lordship may kindly have a glance at.
Which document?
Lord, A/4 at annexure, A/4 at page 11. Hard copy, my lord, I just passed on.
Have you given a counter this
Counter
copy?
affidavit has been served. If my
Have
lord
you filed
friend,
reply?
yes, I have already filed.
No, reply.
Today. No, reply we have not received.
All right, then give him reply. Give him a copy of the reply.
I have given.
Have you received?
Yes.
Just now they gave.
All right, then
Just now they have.
just allow them to go through and then.
Lord, your lordships will remember, but let me say one thing. Lord, your lordship asked the same question that has first been made a party last time. And I made a submission that this letter, the forest letter to the binding officer has never been served on me. Now this AY4, your lordship, I kindly have a glance on which land Advocate General relies. Well, where is the communication to me? And where is my scope to challenge it?
All right, you have not challenged that. Now you are giving, they are giving you this document by way of reply. You may decide to impede, may not decide to.
No, no, you are filing a, when you are ready with it. Where?
I am ready with the Milord, I for impletion of party as a
file in the registry, we will see.
All right.
And Mr. Marty, this document says that to take action against their officer,
Yes.
not you, because he has granted the lease.
Right. Milord,
So you are at the receiving end because your lease has been will be cancelled.
No, no, I will so demonstrate from documents, my lord, that the entire forest officer, there was a district survey report as late as 2021, which was being prepared from 2018.
Just respond to the counter affidavit if you want, and then we will see. Rather, they will have to see the rejoinder.
Your lordship, may I pray that because it was for interim order today.
We will see. We will see next time.
Can I pray for an early date?
Yes, yes. Yes. When?
I will find it there.
When do you want?
Whenever it is convenient to your lordship, except Monday.
Wednesday? Because Tuesday you have another case.
That period of permit will expire.
But therefore Tuesday, retaining its position.
Tuesday. Next week. Is it all right? Next week.
24th, 23rd, 21st, sir, I may. Then your lordship will fix it to Friday.
Friday, all right.
This Friday.
This Friday it is not possible.
Oh, so, sorry, your lordship would be sitting single.
Yes, sir.
Thursday, 30th? No, 30th would be too late. You do not understand the urgency. My entire year will be cancelled for delay. And I will be saddled with a penalty.
Let it come on to Wednesday, Mr.
Wednesday. Any date, 25th, my lord, would be fine.
25th. Retaining information.
This has been e-filed, your counter.
That has been
e-filed today.
On 15th.
The copy of rejoinder has already been solved.
Yes, that has to be.
Let all the pleadings which have been filed and filed be brought on the file. Be brought on the place to be. Yes.
Item number 7.
The impletion party, I am filing that.
That is formal thing.
Yes, formal.
That is formal.
But that may come on record, otherwise if it doesn't.
It will come, therefore we have time.
Item 7.
Not sir. The order has been complied, amount has been paid. I have already filed this, not sir, affidavit, compliance affidavit on not 13th. Must be there on the lordship's record. I have given a copy to my friend.
I will take instruction, let it come tomorrow, Miller. I will take instruction, let it come tomorrow.
Mr. Pradhan.
See, how many adjournments did we grant in this case?
The state council has taken
How
time for
many?
compliance.
No. State government took time.
Yes, my
but
lord.
we kept this matter pending just to ensure
My lord.
that before the disposal of the application, you are paid everything.
My lord.
We were monitoring rather the payment through this contempt application. Because he is a retired person, no?
He has retired since 2012.
All right.
559, my amount was paid, my lord.
All
4
right,
lakh.
tomorrow,
Tomorrow.
Mr.
I don't know, my lord.
Just now he served the copy, compliance affidavit. I
All
want to take instruction by tomorrow.
All right. When was the amount paid?
My lord, on 5th, the treasury was instructed to pay 4,65,000, and my instruction that it has already been credited to his account, my lord.
So did you talk to your client
Yes, ma'am.
today?
Today also after recess.
Today, did you talk to him?
No,
Yesterday, you had talked to him.
no, because of
Last week you had talked to
last
him.
week he had not instructor. He has not been
All right,
received any.
tomorrow. Before coming to the court, you could have inquired from him. You knew that the matter is listed. Only because we are showing benevolence in view of the.
Because every time
All
I
right, we will-
was telephoning him, he said I have not been paid anything.
All right.
Nothing has been
All right.
communicated to me.
All right, we will see. Please ensure whether the treasury has credited the amount or not.
No.
All right, just inquire.
I've given a copy to my friend also, my lord. So-
See, they is a retired person. We should.
No,
be-
no, that's why, my lord, so we have already paid, my lord. I have said
Yes.
compliant.
Case admission item number 8.
Petitioner in this retail case.
Who is the respondent? Give him.
Petitioner challenges of annexure 11 violation. Order passed by the Honorable Single Judge. Page 7.
Dated 10/3/2023. So what is wrong in the order?
That a paragraph 4 your lordship may consider.
Now I. Just a.
In spite of this.
Yes, you are not implicated as party.
Well,
He was not implicated as party. You are not. You are not noticed. No.
The order is also in, Lord Lordship may kindly come to page 77 of the order of the Honorable Single Judge. Paragraph 4.
Yes.
Lord sir, Mr. Sahul on the counsel for the petitioner submits that in spite of interim order passed by this court on 20th of September 2010, in miscase number such and such, the consolidation officer Masagai has already disposed of the matter and case is pending before the Tahsildar Masagai for correction of ROR. Since the consolidation officer has worked out the direction of the Commission on Consolidation, settlement in the order and nothing remains to be adjudicated in the writ application.
in spite of the stay order, the CO has violating the stay order of this honorable court, passed the order.
Sir, how
Without
can you
that
challenge this? What is illegal in this order? Tell us.
That the CO has passed the order in spite of the interim order, then not to proceed further in the case. But he has proceeded and ordered the final order, passed the final order. And the honorable court said that we are helpless. That is why he infructuous, the petitioner becomes an infructuous. A person like the CO, consolidation officer violating the order of this honorable court, passed the order, and if the honorable court has no power, then I have nothing to say.
Lord, the CO's order can be challenged in appeal.
No, but if the interim order was there, how?
Interim
No,
order was
that instruction because the Honorable Single Judge has not dealt with, so I cannot offend same Lord, whether there was an interim order of stay operating.
Yes. Let me go to accept notice on behalf of the opposite party. Number?
3A and 4.
3A.
3A and 4.
3A and 4. What do you want?
I wanted the order rightly passed by the honorable Single.
And also by the CO during pendency of the writ
We are
petition.
not satisfied.
I cannot say about the CO, but the Single Judge has not committed any error in passing the order. It's because there was nothing to be adjudicated.
Mr. Counsel, how could he pass, the CEO consolidation officer pass the order?
That a separate to be,
That is the issue. He could not have passed. So we will set aside this order of the consolidation officer.
Have you examined if the interim order was in force when he passed the order?
interim order was there.
Then the interim order was there, then the order is illegal.
Because that is contempt for against the CEO.
Contempt, the order is illegal, contempt is different matter.
2010. Until further orders. Then to opposite parties to move for variation. That was the interim order. 6/9. Escape and disposal. You wanted the variation order, that means it was the disposal of the. This is not the next one. Not to proceed the person to until further of this court, and it will open to the opposite parties to move for variation of this order. So that means it is not that, it was that case, it was not really, so we will proceed for variation. In this case, has to be disposed of. That page. What's your?
So there is a direction by the Honorable Court to the CEO to dispose of. Page 53, my friend has annexed a document
Let us see.
that there is a direction to the CEO to dispose of the same law.
So sometimes one party comes, takes a stay, the other side comes another petition
So-
for disposal.
Yes, that is the problem, Milord.
Let us find that out.
And very interesting, my lord, the
No,
honorable.
interesting is you have also suppressed that. Why did
No,
you
no,
not
no.
mention that?
No, I have annexed the
You
document.
have annexed, so many things you have annexed, but without mentioning.
Honorable single judge was the advocate in the previous case where the interim order was passed.
That allegation you should not make it known.
And when the matter WPC number 14,182 by
Are you within your
2010.
senses?
Off kar diyo. Where is that order, Mr.
Page 53, your lordship. Page 53, paragraph 4, Milords.
Of the writ petition?
Yes, writ appeal, Milord, where he has filed this document, Milords, page 53. Considering submission made by the parties, this court directs the, in the event, the remand proceeding in terms of the order dated 22/3/2010 in revision case number is pending before the CEO Marsagay. The same may be disposed of within a period of 4 months from the date of normal functioning office of the CEO. This was the direction in
Instead of the stay,
2021.
in another writ petition, there was a stay order. And the honorable single judge was advocate in that previous writ petition. And he refused to hear the matter. Again, the petitioner suppressing all the facts, but number 4, suppressing all the facts, filed another petition and the honorable single judge directed to dispose of
He
this.
is the advocate, how can he hear the writ petition?
That is why the matter was refused. Another bench was, the honorable, your lordship has fixed another bench. But he has passed in the same case, directing the CEO to dispose of those. The order is quite.
Have you understood?
I found another writ petition.
No, that I have seen.
All the thing has been suppressed
Yeah, this I have seen.
in that writ petition. We are not noticed, we have not informed.
So when that order was passed in 2021, you had not appeared in the previous writ petition?
Yes, he has appeared.
Today I received the.
No, previous
not,
writ
they
petition.
may have received.
So I just go through the reference.
But you said this order is perfectly right, the learned single judge order is right, without going through, you have supported the order.
Those I saw it and read. I submitted.
But when the order is against you, that you cannot submit.
No, my lord, I have to.
No. Why are you doing this? You could have asked for time.
I have to go through. I have to go through.
See, this order. This order was not seeing the other side. One week, 2 weeks. Issue notice, so accept notice. This matter on as the first case for first admission. But first admission is not first admission. To be taken up within first 10 cases. Also, at the records of WPC number 7616 of 2021, disposed of on 7/6/2021, the is on record. Yes.
The records of the criminals disposed of it also 2010 may be called when the interim order was passed, because my friend says there was an interim order in that writ application.
2010.
Yes, he says that in 2010, which has been disposed of now, which is not challenged. In that case, there was an interim order.
Yes, we have seen that interim order.
Yes. So if that was in force,
That is there. That is here.
that has to go, Milord.
That record is there.
Yes, Milord.
The order, the writ petition
The
which
first
has
writ
been
petition was
challenged.
filed by whom?
That is here.
The first writ 2010 writ petition was filed by whom?
I am the.
Filed by you.
And the subsequent writ application is filed by respondent number 4, Siroj Kumar Rao.
That is why he has to go through the writ application.
Yes. So if that has been, in spite of the interim order, direction was given to dispose of, the order has to go because there is an interim order.
Order has to go and there has to be something else also.
All right. 2 weeks.
Item number 9.
Item number 9, my lords, on behalf of SP Sarangi, my lords. It kindly be taken up next week, my lords.
As requested next week. Yes.
Item 10.
To my lord, direction, my lord. On last occasion, my lord directed me to show the document. Since respondent was the 139 serial, any person who appointed prior to the petitioner's serial position in person to 1991 pattern. I am giving the also saw the 49 senior, indicating that is that persons appointed prior to
Not appointed. Not appointed. Not appointed.
persons. Last order.
No, Mr. Please. It was not that appointed. It is not appointed. So persons above you were also not appointed. That was the
Persons above. My lord.
Mr. The query was definite that you file an affidavit as to whether the persons above were not appointed. Appointed to there must have been so many persons appointed. That was not the question. The question that question was put to find out and to have it from your mouth whether there had been pick and choose in the matter of appointment or not. That was the reason. So we remember the order. We remember the order. So have you filed your affidavit?
I filed my lord. I have.
Do it again. Do it again.
My lord.
Item number 11.
10.
10. That's fine.
One thing subject to my lord's acceptance. May I forward one thing, my lord. I will file an affidavit. What my lord, because of my I had it wrongly because of I filed an affidavit. I will file a correct affidavit. My lord. But one thing, my lord. One thing, my submit.
The order has not been uploaded.
Hey, upload not at all.
All right, you will see the order.
My lord.
Right now. All right, it will be uploaded. Don't worry, it will come after 1 week. In the meanwhile, you see the order and then.
May I submit one thing subject to my lord's acceptance? The order of termination dated 8/6/2002 was challenged by the petitioner in the writ petition. That order was quashed by Honorable Single Judge on the ground that principle of natural justice has not been followed.
We will not go into that.
Because I am only submitting, my lord, the persons, those that terminated along with me, 39 persons, they were also all taken back, my lord. All the persons were taken back.
We will not go into all those aspects. Yes, next. Tested on the 2 weeks. So as to enable and counsel for the petitioner to duly comply with the order dated
11, order dated 11.
11/9/2000. Yes. 2 weeks. Oh. All.
Next is a pray for some time matter for
How
filing
much?
counter.
How much?
After puja
For?
vacation. After puja vacation.
For
filing objection man counter.
objection to
Matter.
counter order.
Not
Requested on
objection,
behalf
not
of
to, the Lakshmi record is objection, not objection to counter. This is a read of.
Counter.
Writ appeal we will not allow anything. As requested on behalf of the respondent.
Matter.
List this matter on 4 weeks.
After puja vacation.
That automatically comes.
Item number 12.
In 12, my learned friend has sought for some time.
I am on behalf of Mr. Samantrai Mara.
No, no. It was 12, 13.
12.
Sorry. In 12, I.
11.
11 years, sir.
11 years taken time.
Yeah.
It is pending before the rehabilitation stand. It is pending before the FX court matter.
Which matter?
Similar matters, similar that Modananda Sethi case, there are other matters that in Bindusagar
All
Samantara.
right. So when do you want? When should we?
All the matters have been fixed after 2 weeks.
After 2 weeks, that
2 weeks
was last 2 weeks. It has been urgent.
All right. Let it come after puja.
Yes.
Yes, Malay, it will be better. Malay. 12 and 13, both matters.
I am for the 13.
This matter on.
The rehabilitation matter, your lordship may fix up because they have already, it has been directed by single judge to consider the matter. Against the order of consideration that they have come up in writ appeal, which is not maintainable. Because consideration is, this single judge has said they consider the matter. And they have come up in appeal as against that order. And there are hundreds of cases pending before the Honorable Court, your lordship, and there is a rehabilitation appointment to rehabilitation assistant. Lordship fix a small date.
No, writ appeal is not maintainable.
Because they have the
There is
order,
no order.
and a single judge has said to consider the matter.
So they may consider, but under which law?
If they don't, they have to pass a region order that we don't consider. They have to pass a region order that we have, either they have to consider or not consider.
But have they not considered earlier? So that means this is reconsidered.
All right, consider with the simple consideration or in the light of some decision.
That's it. Since rehabilitation assistant, the physical handicapped person, my item
No, not
13.
that.
Lordship, my prayer is that Lordship fix a short date.
Which is
13. 13, I'm mentioning for 13.
So you are physically challenged.
Physical challenge. Petitioner is physical challenge.
What is your?
This is respondent.
The very first day of admission, my lord, the impugned order was set aside. His case was considered under the new rule. He had made application.
Where is the order?
The order at page 37, item 13, page 37 is the impugned order.
Yes, how this can be sustained, Mr. Counsel? Where is the order setting aside?
My lord, para 6, your lordship may kindly see. page 39, para 6, considering the submission made
No,
by
the order cannot be set aside. Very difficult. Order could not have been set aside without giving an opportunity.
That or just not the authority who has to send the application. He
No.
said he is not eligible.
Maybe, but the other side was required to be given an opportunity. First day disposal of the writ petition, setting aside an order.
Hundreds of such matters are being with
Then
daily,
hundreds of matters will have to go back.
and they are considering. So let's see if they are.
At least this order should go then.
Let's see if they're fixing. They are
Is it
saying.
your case that hundreds are being disposed of and they have filed writ appeal and only
No,
four?
no, not my case because she physically challenged.
Sir, counsel, that is not the question. Question is that even if an order is palpably illegal, whether that can be set aside without giving the other side an opportunity to defend. That is the question. That is the minimum. You also assert your right of being heard. So what do you want?
But at item 12 where my learned senior is also appearing, same order, but there the counter was there, only difference. But the operative portion of the order, if your lordship will find, it is the same verbatim, everything same, my lord. So what my learned friend is praying that since in Supreme Court the matter has been adjourned to 2 weeks.
All right, let it come up. Otherwise, they will have to set it aside.
Yes.
Your lordship was be praised short date.
Supreme Court Raji achi pura matter kahin.
That's a short date.
Tomorrow.
No. After puja.
Date will be fixed.
Make a yes, you will
date.
get the date. You will get the date and you can make a mention. You can hear your matter on priority basis.
Oblige.
Yes.
Same date for
Item of 15.
15, I am for the appellant. I may be excused, my lord. Due to my fault, I could not give a copy to my lord and brother, my lord. I am serving the copy today only.
It's a notice.
It is my fault, my lord.
You are for whom?
I am for the respondent number 1.
Who is respondent number 1?
And one of the Coalfields Limited, madam.
It's a notice. So and so accepts notice on behalf of just the opposite party number 1. Let us see the order. Where is the order?
My lord. Next, sir, my
89.
to page 89. This is an order which has been passed. The one of the Coalfields Limited has come before this honorable single judge stating that the police is not giving the assistance to evict the petitioners and others, those who are in possession of the waters. And they are saying that we are not the staffs, but we are the staffs under the contractor and we are residing over the said quarter since long manner. And basing on the observation as page 90, the direction has been given to demolish the same if by giving 10 days notice, madam.
Those have been declared unsafe.
No, madam, the unsafe quarter have already been demolished as per my information is concerned, my lord. And there is no other accommodation. Only I pray only 3 months time if we will be allowed, we will search for the accommodation and we will, and there is an observation has been given.
3 months this.
My lord, in view of the apostate statement, may I read the observation?
No. The writ petition was filed in 2013.
My lord.
This is too much.
And disposed of on February
My lord,
2024.
your lordship, only for the observation is made. For that reason, I have prayed for
page 90. In view of the efforts of treatment of opposite party.
Whatever time you need, but we will observe that in the meanwhile the proceed.
My lord.
See, we will observe that in the meanwhile the authorities may proceed in terms of the observation made by this court. The writ petition was filed in 2013.
Yes, madam.
It was taken up in 2020.
Because, madam.
Disposed of in 2024, and you are
Yes.
seeking 3 months time from today.
Madam, only today, if your
No,
lordship
no,
grant
not
me
at
2
all.
months time.
Not at all.
But there an observation has been, might be that is submitted by the Mahanadi Coalfield Limited that
No.
might have vacated the quarters. Basing on that, that order has been passed. We are in possession of the quarter, my lord. Some quarters has been vacated which are unsafe.
Maybe. We are dismissing it. A writ petition was filed in 2013 by Mahanadi Coalfield Limited seeking police help for this demolition of quarters which had become unsafe for habitation at South Bolanga. The said writ petition was filed in 2013 and came to be disposed of by the order which is impugned in the present intra-court appeal on 5/2/2024 with the following observation. Paragraph 6 and 7. So next, Mr. Biswal and counsel appearing on behalf of the appellant.
Yes,
One
madam. Appellants, both the appellants, two appellants.
appellants submits that
There are several opposite parties are there in the before the unruled single judge.
Two have filed.
Only two have filed.
that if 3 months time is allowed, they said vacate the quarters which they are occupying. Stop. This court cannot pass any such order in the background of the fact that the writ petition was filed in the year 2013, apparently when seeking police help for eviction of the occupants from the quarters which were declared to be unsafe for habitation. Stop. It will be highly inappropriate for this court to pass any order as sought for, any order in the nature as sought for on behalf of the appellant. Stop. Next, we do not find any merit in this appeal, which is accordingly dismissed. Yes.
May I pray? If you will pray for some days, that it is up to the authority, they may consider it. Only that observation.
See, if the quarter falls today, we cannot be a party to that.
It is up to the authority.
It is up to you and them. If we do it, it will be on our heads.
Why I am saying, my lord, because they are residing over the same since last 25 years. And now what happened, there is no other accommodation because it is in a mining area, only quarters are there, my lord.
Mister, please understand two aspects. It is in the interest of their safety.
Yes.
And it is in the interest of the institution's safety also, you may say.
Only that
such order should not
only
be
that much
all right,
observation.
all right.
If it falls on your head, there'll be a lot of other chaos also. And paragraph 6 specifically stated that unsafe quarters. You were saying some are not unsafe. Specifically stated unsafe quarters. No other quarters.
They are stated that they must have evicted in the meantime. For that reason, that order has been passed.
All right.
Item 16.
Yes.
Item 16 before my learned senior Mr. begins. I think we are a caveator here and copy has not been served on us. Let a copy be served, anytime be taken up.
Actually, my
caveat.
grievance is not against OP number
Do
5.
you need a copy of the caveat petition?
No, no, I am I am appearing for the
You are
caveat. So they are supposed to submit me a copy of the appeal memo with interim period.
So what is this
I'll serve
about?
a copy.
So even without
But
you,
actually, my
the-
grievance is not against his case.
Mr. Rath, even without you, the appeal can be decided.
That I know, but that, let me take up the. I have the trial
Because-
court, I mean, on the singular
Actually,
records with me.
I'm not challenging that part of the order.
If we find some merit in the
Yes, yes.
That's fine. That's
then
Yes.
only.
But if your lordship kindly see page 109, 103 is the impugned order. Honorable single judge order, page 103. But a relevant portion which the subject matter of challenge is page 109.
Yes.
Clause 8.2 and 8.3. And 8.2, but I'll start from 8.1.
Who are you?
Sir, I am the principal now in charge of the college. So petition number, apparent number 2, who was opposite party number 5 in the writ application. But the opposite party in respondent number 4, which was 5, who was petitioner in the writ application, he was the principal in charge. Allegation
Who was put under suspension?
The writ petitioner was put under suspension due to an inquiry that was conducted against him.
So caveator. Caveator was put under suspension.
Right. So he was the writ petitioner. There was allegation against him, and the inquiry report was there, preliminary inquiry report. The governing body put him under suspension. The honorable single judge held.
So, but by this order, his suspension order was quashed.
I am not challenging that. The suspension order has been quashed. Subsequently, 8.3, while quashing both the orders on annexure 1 and 5, this court placing reliance on the decision of Dr. Premalata Rao. Premalata Rao is the decision where they have directed to form the common cadre among the lecturers to allow some senior lecturer nearby college, where the petitioner is one of the senior most lecturer. He is a reader, she is a reader, and she is now continuing as the principal in charge after the suspension of the writ petitioner. But my grievance is only this, but I am continuing. Let the common cadre be completed as per the direction in the previous case. Let somebody else come. But so far as I am continuing, but why another person from another college will come? That's the only limited grievance.
So what right do you have?
So I don't have a right, but I have a right to continue till it is done, as I am the senior most, and I have been appointed and approved by the government.
So if some junior comes, according to you, then you can challenge.
But the procedure is the senior most lecturer should be the principal in charge.
So if some junior comes, is appointed as principal, who
Well,
according to you, see, your grievance is that till common cadre is prepared,
framed.
no one from a different college should be
So
allowed.
in the common cadre, nobody junior can be there because I'll be also considered in the common cadre.
Absolutely right. So therefore, if someone is appointed,
right,
the direction is some senior lecturer should be appointed.
Right. I don't have any grievance.
So if any lecturer is appointed who is junior to you, you will have the opportunity to challenge.
Only difficulty is now I'm continuing. Now I'm continuing as per the order. Governing body allowed me to continue, and that was approved by the government. And government has accepted that yes, I should continue. I am continuing as you were suspended, and suspension has been lifted because allegations were there. The court directed he cannot continue as the principal in charge. Somebody else is continuing.
All right. What is the difference of salary?
No, sir. Salary.
Of a lecturer and the
Reader.
No, principal in charge.
Sir, as such, no difference. No, because I am in charge.
You don't want to take additional responsibility.
No,
you are a lecturer. You are getting your salary. You are senior most there in the college. Therefore, you are principal in charge. some person senior to may come. He will become senior. Why
Sir,
should
I
you
have,
unnecessarily?
let me clarify, my
Principal
lord.
in charge.
I have no grievance. My respectful submission is that since in the college I am one of the senior most, and the college I am continuing, no allegation against me.
There is no
Why
question of
somebody,
allegation. There is no question of allegation. It's a question of
somebody has to come from outside. But that's the only grievance. But court has directed from nearby college somebody has to come. Within 10 days, somebody has to come from nearby college. My responsibility is there. But in the college, somebody can't be appointed.
why are you so anxious? That makes your entire case doubtful. That why someone, whether a person, a teacher working in the nearby college, filed a writ petition that see in view of this order, I should be made principal in charge. I am the senior most in the nearby. It's a
No, it is-
principal in charge. No, nothing.
But here the question is not a principal in charge with the same college.
What is the decision in Premalata Raut?
Premalata Raut, you also kindly see this one. Only to form the common cadre.
So relying on that decision, the single judge has,
Yes, only-
single judge has
So that
directed.
was only for common cadre. That has nothing to do to bring somebody from outside. If your lordship looks at the last two paragraphs, paragraph 7 and 8, at page 13 of that judgment. Having heard on a council parties and taking into account the provision contained in the section 10C of the Orissa Education Act, vis-a-vis Rule 8.3 of 74 rules, as well as the decision as cited above, this court, while disposing the writ petition direct opposite party number 1, the state, to take immediate steps for constitution of the common cadre, as provided under 10C of the Act, read with 8.3 of the rules, 74 rules, within a period of 4 months from the date of receipt of the order. And thereafter, the interim arrangement made by the state would continue. The person who was continuing as the principal in charge would continue. But I am also saying the same thing. If your lordship follows this decision also, I am continuing as the principal in charge. And government has approved my appointment. As per 74 rules, actually, the senior most lecturer to continue.
Paragraph 4.4, you say without forming a senior and following the principle of seniority, the lecturer in the college is made in
Is to be
charge.
appointed as the principal in charge.
No, that is being done.
Oh, no case.
These are limited grievances that why somebody from outside should come, why not from the same college? And while I am continuing as such, no allegation against me. And he is a reader, having seniority also.
So you were opposite party number in the writ petition?
Opposite party number 5 in the writ petition. 4 is the college and the principal is open number 5. Principal of the college, in charge.
And this petition appeal has been filed by?
Filed by respondent number 5 was a writ petition.
You are principal or you are a person?
Appeal has been filed by the principal in charge and that person has appeal number 2.
He was terminated, suspended, therefore he was no more the principal in charge.
No, the appellant.
See, the grievance of the post of the principal in charge or the grievances of the a person who was holding the post of principal in charge. How can you maintain this?
Both.
Both.
No, no,
Vijay
no,
Kumar
no.
Patra, therefore, Vijay Kumar Patra was a party.
Yes,
He was the writ petitioner.
No.
he is a party.
Sorry. Who is the appellant?
Appellant is the principal, number 1.
In charge.
Appellant is a
And
person
number
or
2
a
is-
post? The appellant is a person or post?
Yes.
Appellant is. There are two appeals. Sir, suppose. How can you? The present intra-court appeal.
At least till somebody comes and joins, this should continue. That's exactly my case. And the common cadre. After the common cadre is framed.
Intra-court appeal has been referred by the principal in charge from Secretary of SVM Autonomous College, Jagdishpur, through Srimati Bandita Das, accredited appellant number 2, who is the principal in charge of the college. College assailing an order dated 28/2024, passed in WPC number 16154 of 2024, to a limited extent whereby the learned single judge, while quashing the order of suspension,
Yes.
order of suspension of the erstwhile principal in charge.
Yes. Principal in charge.
Principal in charge of the college.
The Annexure 6, the order of appointment.
Has directed the concerned opposite party to allow some senior lecturer of a nearby college to act as principal in charge of the college, comma, till formation of the common cadre. So, the opposite party number 1 was directed to pass an order in this regard within a period of 10 days. Whether that has been done.
No, it has not been done.
So, learned senior counsel appearing on behalf of Mr. Mishra, learned senior counsel appearing on behalf of the appellant, has submitted that the appellant number 2, appellants have submitted that the appellant number 2 is working as the principal in charge of the college without any college, and her career has been unblemished. So, in such view of the matter, comma, there was no occasion for the learned single judge to have directed the who was opposite party number 1?
Sir,
opposite party number who was in the writ petition, opposite party number
Secretary, Department of Higher
Education. Secretary,
Department of Higher Education.
Secretary, Department of Higher Education, to allow some senior lecturer of nearby college to act as principal in charge, particularly when a common cadre is yet to be finalized. So, next. Caveat petition, while IN number 152 of 2024 has been filed. How do you get number? The caveat petition.
But once we lodge the caveat in the counter, caveat will be numbered.
No, but this is not correct as a caveat petition number. Not I. Sure. by the erstwhile principal in charge of the college.
Yes.
Who was put under suspension and whose order of suspension has been set aside by the learned single judge by the impure order.
Well, my submission is, C is not the senior most person. If Lordship will pay C pays 36, there is one more person, Vijay Kumar Biswal, he is senior to this.
So Vijay Kumar Biswal has no problem.
So there is already a senior most person available in that college.
That is why the anxiety.
Right.
No,
So
that's
we are
not,
going
it's
into
not the
that.
anxiety.
No, we are not going
No,
into
let me
that.
clarify that, but let me clarify. But so they are from the +2 wing. There are 2 wings, +3 and +2. Any person who was a lecturer in +2 cannot actually become the principal in charge. So he is from the degree college, the present petitioner.
No.
He was the senior most.
Not a factor. Case 36.
Maybe we are not going.
Right. Not.
He has argued that Mr. Rath, appearing on behalf of the Creator, has argued that the applicant number 2 is not senior most teacher of the college, which submission has been refuted by Mr. Mishra and senior counsel appearing on behalf of the applicant. Next, be that as it may, we are of the view that the petition, that the applicant number 2 was not a party in the writ petition in her individual capacity.
She was a party member.
Not in your individual capacity.
Individual party member.
He was a party also.
Yes,
Okay,
sir.
she was a party.
No,
She was a
5,
party.
number 5.
All right.
She was a party member.
We are of the view that the appellant number 2 does not have any right to hold the post of principal in charge of the college. Post of the
But her appointment was also challenged, but the Contempt could never set aside the same.
report. If any person is brought to the college having more to the college and is senior, based on date of his/her entry into service, there is no embargo in giving the charge of principal in charge of the college. So, but why was this order passed that someone should be
The
brought
reason
from
being, my lord, the reason being, local MLA not being a member of the governing body has shown undue favor to this junior most person to be appointed as the principal in charge. If lordship sees that governing body resolution, MLA is not a member of the governing. He himself appeared, participated in the proceeding, and passed a resolution that the junior most person shall be the principal in charge. That is what was also challenged. That is what was also challenged.
That was challenged, court didn't interfere in that.
Interfered. The honorable, otherwise also if lordship sees, it is only from outside college a person will be appointed in this college. It's not that only the same college employees shall remain in charge of the principal. No. It is only from a outside college a person will be appointed as principal in charge if common cadre is formed. So these people, rather, my lord, I should not say that they have remaining in that college for long 15-20 years. They are trying to create problem. That's the issue.
This is
so that is why the honorable court.
This should have been left open to the
open
to the authorities.
That's left open. The authority will decide it. Kindly see that para 3 and that proviso to sub.
No proviso.
It is not left open.
It is left open to be from outside college. One senior most person will be there. I think there should not be any objection to that.
directs opposite party number one
Yes.
to allow some senior, so this is a direction.
Lord, you are understanding a limit, Lord, kindly see, Lord. Then in that case, kindly see page 36 of the writ petition. But see the junior
Those
most
are all
person.
extraneous submissions.
But kindly see the junior most person.
Just a minute. Oh, to such person. So stop. In any view of the matter, the appellant cannot claim her engagement, her claim the position of principal in charge of the college unless someone junior is
Yeah.
given charge of that position. So, Mr. Misal and senior counsel has however submitted that the direction issued by the learned single judge to opposite party number one to allow some senior lecturer of nearby college to act as principal in charge of the college amounts to a direction for transfer of a senior person of working in a nearby college to the appellant's college for the purpose of his appointment as principal in charge. So he contends that there is no apparent justification for issuance of such direction. So next, considering the facts and circumstances of the case, we dispose of the present writ appeal with an observation that it will be open for the opposite party
Right.
number one to allow some senior lecturer of nearby college to act as principal in charge of the college after effecting transfer of such college, such person, such lecturer or slash
Senior reader.
teacher.
Reader.
Teacher will include.
But they are in the cadre of reader only appointed as principal.
No, there may be professor. No, there is no professor.
No, there is no professor.
Reader.
Reader. So this appeal stands disposed of with the aforesaid observation and modification.
Can I just request?
It is open for the authority to
For
take
all
a
this-
decision.
That means
For all this exercise, a time limit.
the learned single judge had required opposite party number one to pass an order in this regard, within period of 10 days. Stop. And we have been informed that till date the said direction of the learned single judge has not been carried out. Stop. He accordingly observed that it is expected of the opposite party respond number one. Respond number one to take a decision in this regard as expeditiously as possible, preferably within a fortnight from today.
Great.
Item 17.
No, possibly within a fortnight.
May I please, Your Lordship?
Number
17.
Yes. Yes.
May I please, Your Lordship? But here the delay in filing an election petition questioning the election of the present appellant of Sarpanch of the Gram Panchayat having been condoned and the same having been confirmed by the Honorable Single Judge, this writ appeal has been filed. Madam, if Your Lordship will kindly peruse the condonation of delay petition that was filed in the writ petition at
No,
page
whether-
40.
See whether the writ petition which was filed was under Article 227 or not.
But
Both
Decision-
incorporation of that article is not enough. The question is that whether this court entertained that application under 227 or.
but that is cropping up, then I have to assist on that also to your lordship.
What?
Because I know I am conscious of that matter. The full bench
That
decision is
was
also
a
there.
judicial, see, that was a judicial order. Judicial order passed by a court, tribunal.
Conscious of that.
So you cannot.
My lord, will your lordship only give it to tomorrow only?
What for?
Just, my lord. If at
Just
all I
for
can-
your satisfaction.
No, it's not a case of I cannot make that submission with your lordship that for my satisfaction your lordship should
All
have.
right.
If at all I can assist your lordship little better, that much I will
Counsel for
say. I can never say that.
A question has emerged as to whether this intra-court appeal can be maintained against an order passed by learned single judge dated 21/8/2024, passed in WPC number 23, passed in a writ proceeding filed against an order passed by learned additional civil judge bracketed, passed by additional civil judge in an election petition. Stop. The question is as to whether the said the WPC number 23560 of 2022 was entertained by this court under Article 227 of the Constitution of India, and therefore this intra-court appeal against the order passed by the learned single judge can be maintained or not. Full stop. Mr. Mistral and senior counsel seeks adjournment till tomorrow to address this court on the said point as requested. Let's this matter on tomorrow. Yes.
Item 18.
Public.
Granting it matter 2004 ultra virus matter, my lords have already reserved judgment in this.
Granting it blockade.
No, my lord, these matters, the repeal, the Anup Senapati case, that repeal act 2004.
Let it come a day after.
Because that judgment is reserved, so.
So that judgment may come. Let it come a day after.
After 1 week, so that after my lord's judgment, it will be covered.
And just find out how many cases of similar nature are there.
My lord, a batch of cases before my lord's, that was.
That
and
is there.
some
Apart
matter,
from that.
yes, some matters are left out. I will find out.
Item 19.
No. Thursday.
It's in item number 19. You also remembers on 5/8/2024, the collector Noagar, she had appeared before Lordship in person and had given some data with regard to drinking water electricity inside Noagar district only. The Lordship was pleased to direct or to file a detailed affidavit and also directed the OP number 1, the Panchayat Raj department, to file an affidavit with regard to the whole of the state. I talked to her, now in the meantime she has been transferred, she is on maternity leave, so she has paid for 2 weeks time, because now she is the director of Panchayat Raj also, she can file that affidavit. So she has paid for 2 weeks time, so that.
So earlier she was the collector, now director Panchayati Raj.
Panchayat
So
Raj.
anyway she has to file the affidavit.
Yes.
Okay. What about the present collector?
A present collector, in fact,
Affidavit is not required.
no, so far as district is concerned, he has to file an affidavit for the Noagar. So both affidavit has to be filed.
Yes.
Because she now cannot come. She has said that she will not ask some in charge to file that affidavit. She is leave for 3 months. So Lordship may call it 3 weeks after. In the meantime, I will see that I will file both the affidavits by the collector and
on
also
behalf of the state. so as to comply with the order dated
5/8/2024.
5/8/2024. This matter on 4 weeks.
Item number 20.
Item number 20, not this, two petitioners, they are kind of healthcare professionals and their education and the service comes under the Healthcare Professions Act. I have filed the act at flag Y. So kindly have a glance.
What is your?
Once is not this, there is a cadre which has been newly formed by the government under Annexure 6. But under that cadre, the present petitioners, professionals, they have been omitted. If their qualification and education is taken into consideration, there is no provision in this cadre to be appointed even to make an application. That is what the grievance was.
What is that?
Under kindly have Annexure 6. This there is a cadre under serial number 5.
Yes.
So the level has been indicated also, level 7. Their qualification it is required. Clause 2 science, sir, it's equivalent with 2 years certified ophthalmic assistant training course. So here these types of professional, they come which is below the rank of the present petitioners who have their more better qualification, or these are the assistants to the present petitioners.
No, you are referring to entry 5.
Pardon?
You are referring to entry 5 of Annexure 6.
Entry 5, yes. Serial number 5.
What is your problem?
Problem is, kindly have a glance at the Act Section 2J.
Section 2J.
Yes, our Act is at flag Y. I have filed the Acts. Flag Y it has been. That is the National Commission for Allied and Healthcare Professions Act 2021. And have a glance at Section 2. Their qualification has been defined 2J. Now the petitioners comes under 2J. I am placing it. A healthcare professional includes a scientist, therapist, or other professional who studies, advises, researches, supervises, or provides preventive, curative, rehabilitative, therapeutic, and promotional health services, and who has obtained any qualification or degree under this Act, and the duration of which shall not be less than 3,600 hours spread over a period of 3 years to 6 years. 3 years to 6 years. Now, kindly have a glance at Section 2D.
Yes.
2D, there is another kind of professional, allied health professional, includes an associate technician or technologist who is trained to perform any technical and practical tasks to support diagnosis and treatment of illness, disease, injury, or impairment, and to support implementation of the healthcare treatment and referral plan recommended by a medical, nursing, or any other healthcare professional, and who has obtained any qualification or diploma or degree under this Act, the duration of which shall not be less than 2,000 hours spread over a period of 2 years and 4 years, 2 years to 4 years divided. Now here the provision has been made in the cadre list to include this type of professionals, allied healthcare professionals, excluding the superior class, that is health professional under 2J. Now it has been more specified in the schedule also to that Act.
So D is 2-year course and J is 3-year course.
3 years course, because these
Let's come back to 26 again.
Pardon?
Let us come back to Annexure 6.
Yes, Annexure 6. The fifth entry, ophthalmic officer, level 7. Even your lordship, if your lordship looks at entry 4 also, entry 4 includes level 9. There is a blank. What is level 8 also, it is not indicated. At any rate, the qualification has been fixed at +2 science or with equivalence with 2 years certified ophthalmic assistant training course, certified ophthalmic surgery, etc., etc. This 2-year assistant training course that is meant for this, what I beg to submit is this healthcare, allied health professionals, and they are just assistants to the health professionals.
Maybe this is number of public health facilities increase in patient load at government hospital. Formulate Odisha ophthalmic service cadre.
Yes, cadre. This is a new cadre frame for appointment because let's be kindly have a glance at the last column. The entry stage is direct recruitment. Now the present professionals have been excluded. They cannot even apply.
What is assistant director? 5 years as chief ophthalmic officer. Senior ophthalmic officer. Ophthalmic officer.
There is also a schedule to the act. It has been made clear also. If you also can look at page 25 of that act, there is a schedule mentioned in the act. Page 25.
See, this is a cadre which starts from ophthalmic officer. That is the entry stage.
Yes, entry stage.
You on the basis that you have higher qualification cannot claim that you should be included in this.
No, that means in this cadre law, there is no scope of the present professionals to apply even because it is at the entry stage.
So you may have better options.
No, that is not available in this cadre because level 8 is not
every
there.
cadre you can't claim. Let us see that again.
Yes, level 8 is also not mentioned. Entry stage is level 7, then level 9.
That for you.
I don't. No, this is absent.
See,
Lord,
just
I don't
think
know
of.
Pardon?
According to you, a scientist should claim his position in that cadre.
In fact, what I beg to submit is what should be the stage of the position of these healthcare professionals. It is completely absent in this cadre.
It's a different thing. Both things are different. Healthcare professional.
Yes.
Healthcare professional is the core.
Yes. Yes.
And allied healthcare professional periphery.
Are the assistants to the healthcare professional?
Yes.
Yes.
Periphery. And who are at the core? At the core are scientists.
Scientists, therapists, and
therapists. Other professional who studies, advises researchers, supervises or provides preventive why this should be placed at the entry level of
no, that is one question, but even at what level they should enter is also not there in this cadre.
You may become professor.
No, that is not available in this. Our cadre has not been fixed.
Your cadre, what have you done?
Not supposing not unless I apply, the present petitioners apply for any post in the. At what stage this should be applied? They should apply. You kindly have an answer level 4.
What to say? Why are you referring to a particular cadre to say that in what stage you will apply? You may not apply because the entry level is level 7.
Entry level is 7.
And entry level you are not qualified.
I'm not qualified. Yes.
So you are not qualified, and other posts are promotional.
Promotional
or based on experience.
But as experience
at entry level 7.
But the qualified persons under
qualified persons are MS in ophthalmology also.
Yes, I don't dispute that.
MD.
But so far as these 2J professionals are concerned, they don't have any option under this cadre to enter into.
Why they should have option in a particular cadre?
Not even the stage on which they should enter into the service.
Question. No, it's unnecessary. Sorry. Where is your certificate?
Certificate Annex 4 and 5.
Oh, you are under some scam.
Can.
Hmm?
No, that is the name of
That's
that
the name.
institute.
Very good.
State Council for Allied Medical Sciences, Odisha.
Optometry.
And do you have any idea as to what is the difference between optometry and ophthalmology?
That's why I'm referring to the schedule. Kindly have a glance. The difference has been indicated in the schedule to that act.
So therefore, there is difference.
Difference is the other professionals under section 2D, they are just assistants to this present professionals. That is the difference.
Where is the schedule? Which page?
Page 25 of the act. The entry 5, yes. Entry 5, serial number 5 of the schedule.
We do not find any merit. You are referring to what?
Serial number 5. Ophthalmic Sciences Professionals. Serial number 5 that schedule available at page 26. Starts from page 25.
Yes.
Serial number 5 is at page 26.
Internal page 26.
Ophthalmic Sciences Professional, got it? It has been optometrist is indicated, ophthalmic assistant is indicated. There is a no. I'm just placing it. Ophthalmic Sciences Professional is a person who studies eye-related ailments and specializes in the management of disorders of eye and visual system, limited in scope and complexity as performed by medical doctor, having optometrist with minimum of 4 years baccalaureate degree and ophthalmic assistant vision technician with a minimum of 2 years. So one is an assistant and another is a better qualified who
Better qualified, one may have the Nobel Prize, but he may not be appointed as assistant professor of physics. No.
Yes, that's right.
So he may not have the qualification.
So now at least this under this.
At least what? File your affidavit. There is no merit. No, sir.
Notice has to go to copy number 3 and I take notice for 1 and 2.
Unnecessary is not as. And this is filed by association.
No,
By
that has been
association.
deleted. That has been deleted. In the previous orders, the writ petition was also amended.
All right, we will decide it tomorrow. Tomorrow, we'll pass on.
There is also under Annexure 7 also, I placed this before the government. That was not today, till today also that has not been concerned.
Better you pursue that.
Item 21.
Can it be disposed with that observation? I can because that Annexure 7 is still pending.
See, we will not direct.
You can.
You may pursue. You may pursue that. That observation we can give.
Your
Otherwise,
submission we can
we
record.
shall not direct them to consider your representation and dispose it off. As you wish. If you want to pursue, you may pursue.
Well, let it come tomorrow. I'll try to.
Then after making submissions, you should not make this prayer that I may be allowed to pursue. You either take an order or
let it come tomorrow. I'll try to assist.
No, try to assist. You think over it also. Tomorrow also you can make the submission.
The moment you make your submissions and we apply our mind, then we will have
Yes,
to
order has
decide
to
it
be
on
passed.
merit.
Yes, order has to be passed. I don't know. I
Right.
understand.
And before that, you may have the option, but after submissions, you will not have that option.
The problem is, unless there is some kind of observation to consider this, they may not. That's what the problem.
That is, we are not concerned with the problem. We are concerned with the adjudication. That's all.
Yes.
May I please?
21.
May I please, Your Lordship? On last occasion, Your Lordship has a query whether the petitioner complied the rule under 46 clause 2 of making the payments of the demanded amounts. So, to that effect, similar, the petitioner has already paid the demanded amount, which I have find annexed to the accounts details. Also filed a copy to the state.
Yes.
Make the demanded amount under annexure 7A, page 142. I have paid the demanded amount, which I have above on paragraph number petition 11, 12, and 13. I have already been paid the demanded amount in compliance to Rule 46 clause 2 of the Owens Rule 16.
What are you doing? This is what?
This is the account statement which I paid the make the
Your
payment.
affidavit. As requested on behalf of the petitioner, this matter on 2 weeks, so as to enable him to file an additional affidavit, bringing on additional affidavit. Yes, do whatever you want.
22.
T2 Lordship, in the meantime, I have received the order of rejection. I may permitted to challenge that same Lordship.
No, you were supposed to file an affidavit if you had received that email.
Already, that is on record, Lordship.
Where is that
I have already
affidavit?
filed affidavit with annexing the document, Lordship, with noting that is there, Lordship.
Because he had said that he had not received the email.
In fact, Lordship, that email was sent to the spam. That's
All
that.
right.
Lordship, then Lordship, I collected and I have.
Counsel appearing on behalf of the petitioner seeks permission to withdraw this application with the liberty to challenge the order of rejection.
Lordship.
Representation, Lord, Annex
Order
11.
of rejection of petitioner's representation dated
Dated 25th, Lordship, 25/7, 2000.
25/7.
25/7, Lordship.
25/7.
2024, Lordship.
2024. This application, the justice has withdrawn with the liberty as well.
Lordship. Grateful, Lordship.
Item 23.
OGC is still pending. OGC of 1996 is pending. No, with her. 23 with. Yes, you are for?
I am for the Union of India.
Yes.
Okay, number 1.
Yes. It has become infectious or what?
Khandagiri Mela.
So far as nurse in the previous writ application, that is the nurse 2750 of 1996, counter affidavit was filed. Pursuant to direction of this Honorable Court, a committee was formed consisting of the collector, ASI, and other things. They visited this spot nurse and they had suggested something, and that is in form of affidavit by the state nurse. So far as Mela is concerned, Mela is not observed there. So for Mela, this petitioner had no objection. He said that inside the premises of that caves, there have been some encroachment and unauthorized construction laws.
Where are the caves?
Bhubaneswar, Khandagiri, it's called Jaina temples and Buddha and Jain temples.
So whether there are encroachments?
It was found that some persons, the encroachments, they had made some thatched construction for the purpose of selling daily needs for the visitors. And for that, ASI was in, because ASI, Archaeological Survey of India, is in charge of that entire monument, because it has been declared as a heritage monument by the government of India.
Yes.
So the collector had assured the.
But the state government has directed, the collector is directed to remove the encroachment.
You are representing whom?
Why?
Archaeological Survey of India, Union of India.
Prayer is to clear the encroachment.
Earlier writ petition, there was an order passed in 2002.
Yes. And pursuant to the order, there was a committee, action taken report, and thereafter the counter was filed by the state on 13/5/2002.
Thereafter, they forgot about it. This petition has remained pending.
No.
Now the fresh writ petition has been filed to initiate contempt proceedings because I think there is a delay.
No, there is-
I think there is some public interest involved.
Yes, but of course, now the road is completely closed, no road thoroughfare through that way, people are members, and fencing is there. But so far as encroachment, if you are I can spot present status, I can obtain also where's the PIL. Bhubaneswar, outskirts of Bhubaneswar, towards Khordha.
The highway. Near the highway, no?
Besides, about 2 kilometers from the highway.
What is the name of the temple?
It's a monument, Khandagiri, they call it Khandagiri and Udayagiri Gumpha, it's called cave. It's a cave.
Udayagiri and Khandagiri.
Khandagiri, Udayagiri caves. Important.
How to describe?
Khandagiri, Udayagiri caves.
Yes, cave. It's called Khandagiri and Udayagiri cave.
Have you visited?
Seen a lot of times. Huh? I've seen it from my childhood. Last visitor, that is the 1 year back. I had come through that road.
No, not road. To the Gumpha. When had you been?
Inside Gumpha, I've gone 5 to 6 years back. I had been to once with my children. People also direct. Some of them can visit and give a report, fact find whether there is encroachment or not.
The present writ application, these two writ applications. Writ applications. In these two writ applications, there is allegation of unauthorized encroachments in Udayagiri and Khandagiri caves.
Caves, no. Yes.
In the district of Puri.
Khordha,
district Puri.
Puri, now Khordha.
In the district of Khordha, about 6 kilometers away to the west of Vocational railway station. Full stop. It appears from the materials on record that the two caves are of immense historical importance.
Caves are numbered. Caves have numbers.
Yes, Lord. They are numbers, Lord. The cave number 8 is called as Barabhuja cave, and different numbers are given.
The historical background and the significance of the two caves have been narrated in detail in the writ petition. So, next, writ petition. The WPC number of 2024. So, from the order sheet of OJC number 2750 of 2024, it can be seen some committee was constituted.
Yes, Lord.
That where is that? We have an area.
That's so. Committee, as per the order of the Honorable Court, but an affidavit has been filed by the state. With the order, I can just see the lordship, the exact order dated, Lord. If the lordship look at the order dated 20th of March 2001.
So thereafter, you filed the report and that 2/4/2002 order was passed?
Yes.
Okay.
In the counter, I have given the details, Lord.
Okay. 21/2/2000, no? Oh, yeah. Committee was formed by which order? Pursuant to which order? Yes.
Where is that?
Same order, considering the gravity of the aforesaid order.
Just one moment.
In this case, old one.
Old one. Committee was number of orders.
Indeed, order dated 20th of March 2001, paragraph 4, considering the gravity and importance of monuments, we direct the collector Khurda to convene a meeting of the superintending archaeologist, Archaeological Survey of India, Vocational Circle, superintendent of police Khurda, and other officials to think it proper to be present in the meeting. Accordingly, a meeting was convened, Milord.
It can be seen that various orders were passed taking cognizance of the alleged encroachment, at the hills of Khandagiri and Udaigiri. First off, keeping in mind the importance of the two cases which also involves preservation of relics of Jainism, we deem it appropriate, we request Mr. L. Samantrayal and AGA, and will you visit, madam? And Miss and AGA to visit the site on Sunday or Saturday, when? What will suit you?
Sunday also is available.
Sunday it will be open.
Yes, it's open on Sunday, my lord, because Sunday crowd is there more. my lord.
On Sunday.
Because one day it must be closed.
On Sunday.
Yeah, one day only.
So stop. Sunday, and submit a detailed report to the court on Wednesday. Stop. The district magistrate Khurda is directed to ensure that all facilities are made available to Mr. Samantray and Ms. Patnaik to visit and inspect the site for the purpose of stop. We further direct let an officer not below the rank of sub-divisional officer,
Sub-collector.
Not below the rank of sub-collector.
sub-collector accompany them during their visit, which should be communicated by them in advance to the district magistrate Khurda. Stop. The district magistrate Khurda is further directed that before their visit, he must ensure, as far as it is practicable, to get removed all the illegal encroachments. Let us.
Without damage to the-
Without damage to the relics / case. This is matter on Wednesday.
Well, that report we may add one line in between, the previous report which was given.
Yes, no.
That we will add.
I will go with all the details to the collector. So that.
Of the Supreme Court.
Where is the state?
State is, this is the order. I'm sorry.
Mr. Where have you told the state lawyer and counsel who appears for the state?
State 50.
Please inform him. We'll adjourn. We'll adjourn.
Yes, obliged.
No, please inform him. Ask
Yes,
him to be here.
council is here.
Mr. Khuntia has those briefs.
Right.
He also must be having information.
We will see. Call.
All right.
I will give apology.
Just with due apology, my lord, your lordship was dictating that order in item 54 on Thursday, last Thursday.
Tomorrow I'll dictate.
Okay,
Rest.
That's it.
Rest. All right.
Okay.
Tomorrow it can come at a specified time for your lordship.
Tomorrow, yeah.
Today it's there. Today it's there in the list.
What to,
It's there in the list, but no time has been specified.
Yes, yes. The rest?
Can we request us time?
Time.
Three.
Which item is it at?
54. Today's list item 50.
Item number 14.
Yes, this one is a writ appeal against the order of the Honorable Single Judge. That NABARD member is the applicant. The points we were raising is that Honorable Single Judge, your lordship may recollect, said that the inquiry officer acted as the presenting officer. That suffered from an error of record. We have shown those paragraphs. And so our points we have formulated, members, so we have given a very short note today itself. Note to the-
Yes, sir. Please take your seat. Please take your seat.
May I just quickly run through the points?
Yeah.
First one is the order has errors of record, and those I have mentioned under that heading. In fact, there was a presenting officer who presented the matter on several dates. Documents were also produced. Then second
No,
point
but
is
if we remember correctly, it's a case where the inquiring officer started putting questions. He started the proceeding.
That is the finding of the Honorable Single Judge. But
Achha, that is contrary to
the record. Those
Yes.
pages I had shown. What the Single Judge says, if that is correct, then that comes our second point. That suppose you find that there is a violation of natural justice, then you will have to relegate it back to that stage. So that's our second point. At page 2 of my note, I have mentioned it. Yeah. Then the third point would be that earlier there was a writ petition order by the single judge, which has attained finality. There the matter was remitted to the appellate authority. And thereafter the appellate authority has now passed the reasoned order. That order of the appellate authority has not been taken note of by the Honorable Single Judge at all. Not a single line of that appellate order has been considered. That's our third point. And there was a...
No, but why was the matter remanded back to the appellate authority? What was the flaw in the order?
The reasons, the appellate authority had not given adequate reasons, and the chairman who had heard the appeal, he was earlier the MD, so there was some technical flaw there. So those portions also I have quoted in my note. Now that order was challenged by us in writ appeal, we didn't succeed, but the respondent accepted it. So in terms of the earlier single judge order, the appellate authority heard him afresh. And then that order came to be challenged before the second round before the High Court.
So is this a submission that now the challenge should be confined to the order of the appellate authority?
Indirectly, because my lord had correctly asked me a question that before the first original disciplinary authority, he didn't appear for whatever reason. We tried to give him notices, he didn't accept. So he was unrepresented before the original disciplinary authority. That was a ground of challenge before the earlier single judge. The honorable single judge earlier in his wisdom remitted it back to the appellate authority and not the original authority. So there that question may come up that whether that can be now revisited again. I have got one judgment which says that these principles of constructive res judicata would also apply to writ petitions. But in any case, the reason for him not being...
No, but that will depend on the grounds which were taken before the appellate authority in the appeal. So if before the appellate authority, like the grounds were taken that the inquiry officer acted as like, and if the appellate authority fails to address that point, then that point is available for him to take in
I'm not saying for a moment that this cannot go back to the first authority now, but that may be an
not
accident.
always, not always, but in certain circumstances, like if he does not challenge the procedural illegality in the in the proceedings of the inquiry proceeding. So if he does not challenge that, and then the appellate authority decides on the basis of the points taken, then it may be difficult for him to challenge because that attained finality up to the writ court.
I bow down.
So that these are the circumstances in which the court can go to that the proceedings. Yes.
Here, if your lordship would see, the crux of the case is at page 6 of my note.
Yes.
Page 6, paragraph 8, wherein I have quoted Rule 44 of the NABARD Staff Rules 1980. They have also given hard copies. If your lordship wants, I can show the entire rules. Now, Rule 44, if your lordship sees, says an employee shall so manage his private affairs as to avoid insolvency or habitual indebtedness. An employee who is in debt shall furnish to the competent authority a signed statement of his position half yearly on so and so date, and shall indicate in the statement the steps he is taking to rectify his position. An employee who makes a false statement under this rule, or who fails to submit the prescribed statement, or appears unable to liquidate his debts within a reasonable time, or applies for protection of an insolvency court, shall be liable to be dismissed. So here, this underlined portion squarely applies in this case. So here he had failed to submit the prescribed statement and was unable to liquidate. So now, if the order impugned in this writ appeal is allowed to stand, then this would amount to rewriting that express rule of the staff rules, this rule. Order of reinstatement now has been passed against us. So if that is allowed to stand, then this would amount to rewriting Rule 44 of the NABARD. Now, this was specifically drawn to the attention of the Honorable Single Judge by way of notes, including these rules. This has somehow escaped the notice of the Honorable Single Judge, this point. So this is something which I had not drawn your lordship's attention in a specific manner earlier. So this is something which stares at me. And the appellate authority has dealt with this in paragraph 17 of its order after remand by the High Court, giving him personal opportunity of hearing also. Now, if your lordship would see, earlier your lordship had asked me a question that why didn't he appear before the disciplinary authority? Here, page 6, paragraph 9, we have given the documents which is a part of this record.
In the which order is under challenge? 26/4/2024.
My lord. The judgment begins from page 22.
Paragraph 12, we are challenging paragraph 12. Paragraph 12,
My lord.
it was not remanded to the appellate authority.
No, this was the earlier round.
Earlier round.
Earlier round.
Which is the order under challenge? This is 26.
Order under challenge is at page 22, my lords.
Page 22, yes.
Page
We are
22.
there.
This is the order impugned in the present return.
So please come to page 11.
Page 11.
Oh, in the first case, the appellate authority was directed.
Paragraph 12. Page 11 at page 32 of my brief, my lords. Internal page 11. Paragraph 12. Was the order of and the order of the appellate authority dated 17th October 2019. I hope my lord finds this.
Yes.
So now this appellate authority order dated 17th October 2019. This was the order passed on remand by this court. Now, in this impugned order, now the Honorable Single Judge has quashed the appellate authority's order without looking at it. There is no discussion why the appellate authority's order is bad in law. This assumes significance because the matter was remitted to the appellate authority by virtue of the orders of this court. So at least that order should have been looked at. Now,
where is the earlier order?
Earlier order would be at page number 161. The relevant portions are there. It begins from page 148. Begins from page 148 and the relevant portions would be looks from page 161, that is internal page 12, paragraph 8. I hope my lord finds that. So far as merit of the case is concerned, admittedly 4 charges have been leveled, which are as follows. The writ appeal, our page mark is page 160. And below that would to be important. It is admitted position that the petitioner has not availed the opportunity to participate in the inquiry. However, he has tried to justify that he had not been provided opportunity. However, the opposite parties have come up with several documents in support of their argument that they have tried to ensure appearance of the petitioner, and when the petitioner has not put his appearance, they have gone for paper publication. And thereafter, on the basis of paper publication, the petitioner has made correspondence to defer the inquiry. But according to the petitioner, the same has not been deferred. And in one day, the inquiry has been concluded. As such, the allegation of malafide has been alleged against the management in proving the charge and inflicting punishment or dismissal from service.
Yes.
And conclusions after relying on Supreme Court judgment would be from page 165. Page 16, internal page 16. matter was remitted back and opportunity of hearing was also required to be given, which we have done. Now, this appellate order is not discussed at all by the Honorable Single Judge. Now, this order of Honorable Justice Prasad was challenged by us in a writ appeal, and our writ appeal was dismissed. Manoj, just to sum up, Manoj, our points, we have mentioned it in the note. The impugned order has errors of record that I showed regarding the presenting officer. That I think, Manoj, that's telltale. Three, 4 dates. There was a presenting officer. He presented the charges. He showed the document, and thereafter the inquiry officer has given its time. So that is clearly an error of record. Second would be that if you find that there is a violation of natural justice, you have to relegate it back to that stage. That principle has not been followed. Then the earlier orders, which I just showed, my lord, of Honorable Justice Prasad, there is a specific finding regarding his absence. So that has, in a way, attained finality. Then, my lord, the appellate authority in paragraph 17 has discussed about this rule 44. Rule 44, which I showed, that you have to give this, otherwise the only other penalty is dismissal from service. There is no discretion left there. So this rule has been rewritten by virtue of the impugned order. That would be basically in the judgment, my lord, Nilima Srivastava versus State of UP. That would be relevant. We are giving ticket.
Yes.
Paragraph 31. The division bench of the High Court proceeded as if it was hearing an appeal against the judgment dated so and so of the single judge, which had already attained finality. The appeal filed under rules of the court was filed against judgment so and so. It is well settled principle that a letters patent appeal, which is in continuation of a writ petition, cannot be filed collaterally to set aside judgment of the same High Court rendered in an earlier round of litigation, ignoring the principles of justice and the doctrine of finality. Then Naresh Nirajkar has been noted. Para 32. Para 33, Rupa Ashok Hura has been noted. Para 35 would be relevant. Thus, it is well settled that it is not permissible for parties to reopen the concluded judgments of the court, as the same may not only tantamount to an abuse of process.
Yes.
These are our broad points. And regarding the relegation, those judgments I have mentioned in my note.
Yes.
To find that there is a violation of natural justice, you have to relegate it back to that stage. So, order of reinstatement could not have been done. That's our understanding.
Yes. Before you, just a minute. Before you begin
you just come to the earlier order of, please stand up. Listen to our question, then respond. Please come to page 12 of the order which was earlier passed. In the previous round of litigation. We can provide you a counsel. Why are you appearing in person?
Well, I am also an advocate.
Please come to page, you are an advocate, all right. Come to page 12.
161. No?
You are practicing since when?
Practicing after leaving the job. But
Since when?
Here and there, small. I'm not a much of an advocate.
No, since when? When did you get enrolled?
2009.
Huh?
2009.
2009. Have you stated somewhere?
No, at that time, filing that, I was not an advocate.
Whether this fact is there on record?
No, my lord. It was not there because 2007, I filed the writ petition. At that time, I was not part.
No, whether this fact that you are a practicing lawyer has anywhere come on record?
No, my lord.
Since 2009?
2009.
All right. So what is your annual income? Any idea?
No, I am not earning much. I was not a good practitioner.
Much means?
Around 40 to 50,000 rupees. 5, 6,000, 10,000 in a month.
40, 50,000 per month?
Per year. Annually, 4, 5,000, 10,000 I am getting. Not much.
So do you file your return?
No, ma'am.
You don't file your return. All right. Please come to page 12 of the internal page 12.
Well.
Internal page 12, have you seen this? It is admitted position.
Well.
You did not avail.
Well.
So this is a finding recorded by the court.
Well.
So how can you overcome this finding?
Well, actually, when that order was passed and the writ appeal was also dismissed, I was given an opportunity to file before the appellate authority. So I filed a fresh petition. So I prefer not to appeal against this order because this is in my favor.
No,
but in the second writ petition, I have taken all these positions.
That is the whole difficulty.
I have not been given the opportunity.
That is the problem. That is the problem. That there is a finding which.
And my lord, actually, my submission is that even if not admitted, but even if it is there, they cannot take the opportunity that they will not hold the inquiry properly. They will not produce a single document for the exhibition. Not a witness was examined. Not the competent authority has given a speaking order. Not they have not gone for all these rules. Paraphernalia, nothing was there. Inquiry officer has not exhibited a single document. He has not supported his report by any evidence. That I have all gone through that. And my lord, because
now, if we can we pass an order for your reinstatement?
My lord. So,
can we?
My lord, yes. Because my lord, in a nutshell,
because you were already a lawyer.
No, my lord, I'll just say, I have been dismissed from the service on
you
two
were
charges.
Dismissed from the service, but
my
you
lord,
were practicing.
Okay. I have been dismissed from the service.
Your memo of appeal.
My lord, one thing I'll tell you, I have been dismissed from service on two grounds. One is I have availed a 30,000 rupees loan without permission of the bank. Another charge is that I have not attended a single training program. That's why the single judge has observed it is a disproportionate to charges.
Where is
And
your memo of appeal?
I have given my letter. I have already tried. I have already filed.
You have already filed it. It is difficult for us to-
Annexure,
Memo of appeal, that the reply affidavit I have given.
you're not here.
You had filed appeal before the appellate authority.
My lord, my lord.
Where is that?
My lord, page 167, internal page 129. Page 167, internal page 129.
Fresh appeal. 129 is filed.
They have given me an opportunity to file the fresh appeal. No? That
Opportunity was given to you to file fresh appeal.
my lord.
It starts at page 100. Repetition mein.
My lord, that is 166. Internal page 129, judgment of order of the previous year, last para. Accordingly,
1 moment, please.
appellate authority has not.
Just a minute.
Annexure 15. Part of annexure 15. Appeal along with order.
How could you find fresh appeal? Let us see the order, yes.
Well, that last para goes. Accordingly, this court is of the view that the appellate authority has not exercised its quasi judicial mind in proper manner. Hence, the court, without making any objection on the legality and propriety of the order passed by the disciplinary authority, is remitting the matter back before the competent appellate authority by quashing the appellate order to decide the matter, the appeal afresh, after providing opportunity of hearing to the petitioner within reasonable period.
Just a minute.
So where is
This order was passed when?
Well, it was passed on
4th May 2018?
14th.
So there is
Show us a memo of appeal which was filed by you before filing of this writ petition. It was disposed of on 14 May 2018.
because what you have just read out, there is no direction for filing fresh appeal. So show us your original appeal.
Original appeal.
You could
Memo.
not have filed another appeal.
140.
143. No, says original appeal is also there.
Yes.
Because our index says that is the fresh appeal. No.
running page 143
Okay, what?
of your lordship brief. In the writ petition, it was annexed as page 105.
105.
143 in the writ appeal.
All right. Let's see.
He's saying this appeal it is 105. Annexure 13.
Annexure 13 series.
Annexure 13 is in the writ appeal. Sorry, writ petition.
7th
105, yes.
7th November 2005.
Yes, got it.
So this appeal was required to be considered. No other thing. The points which you have taken in your this appeal dated 7/11/2005, that was required to be taken. Cannot develop your different beyond that.
Well, that will be also sufficient, that I have taken all the pleas in that also. Well, I would like to add that is the points he has raised before you. Can I comment?
Just read the appeal.
Come to the your memo of appeal.
Memo of appeal.
Yes, the first memo of appeal which you had filed in 2005. Yes,
143.
the first appeal memo which you had filed on 7th November 2005. So
Right.
there, the grounds you have taken, please.
Which appeal has been filed?
Yes, that the subsequent
Appeal was not required to bond.
But if he had raised the points in the earlier appeal, maybe.
both.
Let us see what grounds he has taken in the first one. Says it covers, then we can see. Different view.
The second one is the order of the authority is at page 190.
So your officials have allowed you to raise or open up all the police.
So they have not specifically dealt with the appeal memo.
Let us see
Since
with your
that is at page 190. 190. It begins from page 190.
Basically 3 points. One is that he had not replied to the charge sheet, which he says he has an opportunity to defend himself because he says, I did not receive the notice, but he had not given the address. Then disproportionate punishment.
My lord, I have given the address and that is recorded in the inquiry report itself.
Sir, counsel, there is a finding of his own that you did not avail the amount.
Well,
That finding we cannot have different opinion. So that has become finance. You did not agree.
my lord, I will not. I'll bow down to that. I will not touch upon that, but I'd like to go to the other points that he has raised or I have raised. That Aji is saying that it is a relegation to the competent authority again. I have cited 10 citations from the Supreme Court. After 19 years, it cannot be relegated to the appellate because none of the witnesses, because in the single judge has dismissed the appeal in the petition because it was the procedural lapses are there. They have said that I am the presenting officer has presented the cases, but not a single document was examined or vouched by anybody. Not a single witness was examined. I'd like to go on that point, even if I have not attended, even if I have not taken the opportunity. I'll go to that. The inquiry officer has not examined a single witness.
Original reports are here.
Yes, ma'am.
Original reports are here.
Original records on proceeding, all records he had given in the repetition, they are part of the written.
Part of the writ appeal means you have annexed.
We have annexed the entire
Okay.
repetition with annexes, so they are there. Annexure 2 and the records, what was produced before the authority, that my lords can find from page 99. The charges are from page 99.
Writ appeal, page 99.
My lords.
Means part of annexure 2.
Page 99. Writ petition number, page number would be 61. Annexure 1 series.
Copy of charge sheet.
Charge sheet.
The index of the writ petition, so copy of charge sheet.
Madam, for that matter, all the annexures, inquiry officer report in the Delhi Rojanama competent authority, I have given in the page 34, annexure 2 of my read petition. Everything I have given. Copy of the competent authority, Delhi inquiry report, inquiry proceeding, everything. I have page 34, annexure 2. I have annexed everything.
Page 34, my friend.
No, you tell us.
Annexure 2 is his writ petition. So
writ petition, all annexure I have.
Yes. And that begins from, I showed the charge sheet, it's page 99. And regarding this documents, my lord may see thereafter. Page 109.
Annexure 1 series starts
My
with the charge sheet.
Then regarding this proof and inquiry officer and presenting officer, that would be at page 114. After a short brief developments of the case, the undersigned asked the presenting officer to put for the details of the charges against Sri DPS Malik, manager, the charge sheet officer, Sri N. Sunil Kumar, presenting officer, placed all the charges made against DPS Malik as on.
No, this is before. But where is the network, the evidence? Where on behalf of the side, when you have your all reports are there.
Thereafter, my lord may see the documents which have been mentioned, page 119.
No, such a before.
My lord.
And this is the
Yes, Amit, my lord, I will draw your kind attention to 134 of the running page and inside internal page 96, whereas the inquiry officer in his report has said analysis of the evidence, the charges are analyzed from various angles, details of which are as follows. After that, he has not said anything. Then he has started mentioning about that. That's why not a single witness. In that same para, you see, when he is supporting that charge number 1, in the margin, he has not given any document. Whereas you see the charge number 2, he has given exhibit number this and charge number this.
There are those records. Like first day, you did not appear, second day.
It's there.
These are there.
Those are there.
Where? The documents are there, but the order
No,
sheet.
the documents with which they
Order
want to
sheet.
prove the charges.
Do you understand
My lord.
the meaning of entire reports of the disciplinary proceedings?
I have annexed. Total, I have annexed, but I have shown there that they have not a single witness was examined, not a single document was examined, exhibited.
All right, what happened first day for the There is that. What had happened on the first day of the
Inquiry. First day, the inquiry proceeding is at 112. And second day's proceeding is 119.
One four, top it's written first day's process.
your case that even if you don't like charge sheet, they have to prove the charge.
And refer to page number 119. Why the single judge has observed that the inquiry officer has questioned first, that can be known from that. Kindly refer to page number 119. My lord, and I'd like to submit, my lord, on the points he has.
Give your written note.
I have that.
We will not. We don't have any time. So much time.
I have given the reply affidavit. That
You have the
my lord.
In order to continue. Had this matter. In order to refresh the memory, Milord, I may be permitted to place the little bit facts. Your Lordship had this matter earlier. That I have given a dead chart because it is a checkered career, this dispute law. That the advertisement
Yeah. Previous.
that this dispute relating to the finalization of the sand side and that the advertisement was made in 2019. I have given a date chart for your Lordship's reference. That the advertisement was made in respect of 3 sand sirats in 2019, and that is Balitola Sandkori, Sabara Sandkori, and Sangagua Sandkori of the Bonai subdivision, the Bonai Tahsil. And the petitioner and the opposite part number 5 are the participant to the said bid process, and the opposite part number 5 has participated in respect of 2 sand sirats. That is I have given in my, that is Sabara sandbed and Sangagua sandbed. Petitioner was the participant in respect of 1 sand sirat, that is Sabara sandbed. And petitioner quoted the price, highest price, that is 169, 186 for Sabara Sandkori, and in respect of Sangagua Sandkori, he has quoted 169.
Appeal was filed under which provision?
That appeal was filed under Rule 46 of the Orissa Minor Mineral Concession Rule.
The short point is that one bank.
Yes, madam. In respect of 2 sand by sandbed, he was declared as the highest bidder, but he has given 1 solvency. Though he has required to submit 67 lakhs of the solvency certificate, but he has given 1 solvency.
No,
In respect of 2 sand quarries.
67 lakhs each.
No,
67
1
lakhs
each.
each.
In respect of 1 million is 32 lakhs 92,152
And the
in
other
respect of 1.
Other one.
And the other is 34 lakhs 87,822.
So doesn't that cover that 64
No.
lakhs? Doesn't it cover?
No.
Short by how
Because
much?
he has used 1 solvency certificate in respect of 2 sand sirats, 40 lakhs.
Maybe, but how much is the?
Amount is 67 lakhs 79,000.
Hmm.
Total is 67 lakhs
He has
79,000.
given for?
He has given 40 lakhs.
bid you want to use that for?
No, that was not.
No, that is
The
the
competent
reply.
authority, the competent authority.
Tahsildar has
select-
sumo to give it.
And
He has
Sumo
not
gave for
withdrawn,
one.
he has not withdrawn any of the bid.
No, exactly. Okay, okay. So Tahsildar gave for one and
Ma'am.
asked that some letter has
And,
gone
and,
to him.
and he was successful in both the bid.
So Tahsildar himself.
himself invited
Himself
for
given
one
one
bid.
bid.
Tahsildar invited him to finalize the lease in respect of one bid. Though he was selected for two, and there is deficiency in solvency, and he used one solvency in both the St. Cyrus blood. The Tahsildar is not required to ask him to finalize the bid in respect of one. The Tahsildar has no choice because he has to surrender one if it is to be selected for one bid.
So his thing is that he did not surrender.
No, he has never surrendered. And so therefore this
So the
honorable court,
solvency he had given for which one?
In both the Saira.
in both the Cyrus.
Same one in both.
Yes. Your Lordship, for that purpose, your Lordship can see your Lordship's order dated. That in view of this deficiency, my Lord, earlier, your Lordship can see 21/6/2021. Order number 3. 6/2021. Yes, ma'am.
So this Saira is waiting since 3 years.
3 years, no. After when the petitioner objected,
No, so this Saira is not being.
not
used.
being operated till today, though I have been asked to match the price he has quoted, and I have already matched, and Miller,
No, it's all right. So till now it is lying without being used.
lying as such. Till now it is lying as such. The Lordship kindly see the order dated 21/6/2021. Due to this deficiency, this honorable court specifically directed the state government to file the affidavit whether in paragraph 5 of the order.
Yes, sir.
Yes, ma'am. May I place the entire order? It will be easier for appreciation. There are two St. Cyrus queries in question in the present case. One is the Sabra St. query and the other is the Sangagwa St. query. It appears that the appellate order was passed, opposite part number 5 was still pursuing. It appears that the appellate order was passed, opposite part number 5 was still pursuing the award of both St. Cyrus, and today, for the first time, the court is informed by Mr. Dalai that opposite part number 5 has given up one of the above St. Cyrus, although he was not clear which one. The central point of challenge in the present petition is that having bid for two St. Cyrus, opposite part number 5 ought to have given a solvency certificate which is equivalent to the value calculated for both St. Cyrus. The calculation has been set out in paragraph 10 of the petition. The court directs opposite part number 1 to 4 to inform the court what the correct factual position is, and in particular, whether opposite part number 5 has in fact given up one of the St. Cyrus, and if so, which one. Further, they will confirm if the calculation of the amount for which the solvency certificate had to be furnished as set out in paragraph 10 of the writ petition is correct. These are the two queries made by the Honorable Court, and accordingly directed the opposite part number 1 to 4 to file the affidavit. And the opposite part number 1 to 4, the state filed the affidavit at page 158. The first affidavit at page 158. At 157, starting from 157, your Lordship can see the 158. in the present, the paragraph 5, last paragraph. Let's got it now. In the present case, Sri Fakir Mohan Naik, opposite part number 5, had submitted 2 bid applications in Form M before the Tahsildar Bonai in respect of Savras and Puri and Sangagwa Puri with one solvency certificate of 40 lakhs instead of 67,79,974 as required under Rule 27.4 of the Odisha Minor Mineral Concession Rules 2016. It is an admitted fact that the opposite part number 5 has never withdrawn. You can mark it. It is an admitted fact that the opposite part number 5 has never withdrawn his bid either in respect of Savra Sankori or Sangagwa Sankori before opening of the bid, that is 9/1/2020, or after opening of bid. The then Tahsildar Bonai, without rejecting both the bid of opposite part number 5 due to deficiency of solvency on 9/1/2020, had opened both the bids of opposite part number 5. In both the bids, the opposite part number 5 was the highest bidder. On 16/1/2020, the then Tahsildar Bonai wrote 2 letters to the opposite part number 5, intimating therein that after scrutiny it is found that the solvency certificate, miscellaneous certificate number so and so, of rupees 40 lakhs only, which is attached to in tender applications of Sangagwa Sandbag, is also attached in the tender application of Savara Sandbag, in which you are the highest bidder, and further directed to submit new solvency certificate or bank guarantee of rupees 32,92,152 within a period of 7 days, failing which the application of the Sangagwa Sandbag shall be automatically rejected. On the same day, the then Tahsildar in another letter declared the opposite part number 5 as the successful bidder in respect of Savara Sankori. After receipt of this aforesaid letter on 22/1/2020, the opposite part number 5 wrote a letter to the Tahsildar Bonai intimating therein that I am unable to deposit rupees 32 lakhs for Sangagwa Sandbag due to my financial problem. So I have no objection if the highest bidder shall be rejected in my favor. Copy of letter number so and so, Bonai, a copy of the letter number so and so are enclosed herewith and marked as annexure A/3. It may be noted that the opposite part number 5 has never withdrawn his bid either in respect of Savra Sankori or Sangagwa Sankori before opening of bid, that is 9/1/2020. Answer 1 is advertisement. Translated copy. Yes. This is the translated copy of that. Is it 31 is the translated copy of page 32.
So you have given only 31.
Yes, ma'am.
32 to 35 we cannot read also. Same part of that.
But the relevant part is annexure 2 year loss, you can see, page 36.
You're asking about one.
32 to 35 are not, 32, page 32 translated copy is page 31. So page 33 to 35 I have not given. Yes, yes. That is relevant. Yes. But I will supply it. Translate. Yes. Yes, ma'am. I'll.
Legible copy in Oriya as well as translated
Yes, yes.
copy.
I'll show. By way of an affidavit. I'll show.
Annexure 1.
But next week and
Item 49.
the lordship fixing it to Tuesday.
Sir,
Mr. Dale, have you given a legible copy of the advertisement?
No, in fact, Lordship, that document, I have given all other translation copies of the all documents.
Except this one.
Because Lordship, their document that is not legible to Lordship. So that
Okay, no, because there
It
were
is
some
also
legible
your
copies,
document
so
also.
you
I have given the entire translation.
You have also applied for on the basis of that advertisement.
I have given the all relevant, that was the order for shorter Lordship.
No, you have given translations. Have you given a legible copy of that advertisement?
Legible copy, I have given legible
Exactly,
copy.
I saw
Legible
that.
copy, Lordship. That copy I have annexed.
The translation
But
is
no,
not.
translation copy I have not.
Okay.
Okay.
49.
May please your lordship. Here, milord's petitioner is a oil company, that is Bharat Petroleum Corporation Limited, has challenged the order passed by the Honorable Single Judge directing to give the dealership to him. If the lordship will kindly turn to page 94 of the writ appeal. 94 of the counter affidavit of the writ petition. The writ petition. Yes, please. If your lordship, page 30, operating portion of the order, as aforesaid by order dated 16th November 2019, the writ petition of the other petitioner was disposed of. It will be noticed from the above extract of the said order, the division and found petitioner is continuing to enjoy the contract for last 15 years. Petitioner can only mean partner of herein petitioner's husband and the farm. The husband, as also aforesaid, was added as a party on 13th August 2019. This fact, coupled with the husband's clear contention of reason for wanting to have been added as a party in the writ petition, makes it clear that his partner had accepted the resignation and thereafter proceeded to run the arrow on his own. Furthermore, disposal of the writ petition vacating the interim order restores the order of termination dated 30th January 2011. As a consequence of the said, the dealership itself too terminated long before the notice of the petitioner's application in response. As such, there can be no confusion thereafter the interpretation regarding whether or not family unit of the petitioner is involved in running the arrow. Here, the facts are like this. Petitioner's husband was a partner to another retail outlet of the Indian Oil Corporation Limited. There was an advertisement in respect of Bharat Petroleum Corporation Limited, where his wife filed an application. Under the guidelines of the company, I am only placing it, they are all on record. Multiple dealership or distributor norms means that the applicant or any other member of the family unit should not hold a dealership or distributorship or letter of intent for the dealership, distributorship of any oil company. That is only one retail outlet, so and so will be allowed to a family unit. Here, my lord, she filed an affidavit that my husband has resigned long since. But to this, we obtained instructions from the from the Indian Oil. First of all, they replied that he still, as per our records, page 23 minutes, her husband still continues as a partner. Thereafter, minutes, we have obtained from the Bharat Petroleum, I have filed with an additional affidavit. We have obtained the partnership deed which was supplied to us by the IOCL. He still continues as a partner. This deed runs like the partnership is for a period of maximum 20 years and further extension as per the mutual understanding. Any premature dissolution, except in case of death of a partner, shall be done with the prior written consent of the company. That is means IOCL. But here no such thing was done. But still then, on the submission of the petitioner, it was directed to give him the dealership. So that has been challenged by us in the writ appeal. In the nutshell.
The documents which are you are now bringing on record.
Yes, yes. This document which I placed before your Lordship will kindly see order number 2 in the writ appeal. Order number 2 in the writ appeal. Order number 2 in the writ appeal.
These documents were never before the single
Yes,
judge.
order number 2 in the writ appeal. This matter is taken up by virtual mode, stroke physical mode. Learned counsel for the appellant prays for time to obtain certificate from the Inspector General of Registration relating to the partnership in respect of Ma Santoshi filling station right from the inception of the partnership till today. Because thereafter we sought for this document from the Indian Oil Corporation and they supplied this document to us.
But the order was to get from Inspector of General of Registration.
Millers?
That order, what you read.
For the inspector, but this was never done with the inspector.
That
These
means
documents.
the partnership was never registered.
No, partnership was never registered. Dealers, according to them, dealership was terminated.
Husbands.
According to them, dealership was terminated in 2011. But we obtained instructions from the Indian Oil Company. It is still continuing. As per the records of the Indian Oil Company, they say it is still continuing.
Dealership.
Other dealers.
Which place?
Minutes?
Which place?
Minutes I'm giving. That is at annexure 4 in counter affidavit. Writ appeal annexure 4 at page 35.
Which place?
Page Nuapada. District Nuapada, Odisha.
This dealership was terminated.
They say it was terminated. Then they filed a writ application. The other partner filed a writ application. That was status quo order was passed and was continuing. So my humble submission is, we relied on the documents supplied by Indian Oil Corporation.
Just a minute. This was terminated in 2011.
Yes.
What about the present question?
Present place in question is Mirror.
When was this advertised?
2014 it was advertised.
After 2011.
Yes.
What is the meaning of status quo?
Continue as a partner.
No, 2011.
Yes.
This was
Yes.
When was the order of the status quo passed?
That minutes, I'm not exactly certain.
So therefore, if that order was passed after 2011, then what is, was it a status quo ante?
Because that, my instruction is still continuing.
Still continuing, according to you, it was terminated.
No.
You should be sure whether it was terminated or not. And even if there was an order of a status quo means the
As your lordship observe that all company might be continuing, partnership will not be there.
no. The dealership.
And dealership is continuing.
Dealership, according to you, it was terminated in 2011.
11.
If it was terminated in 2011.
But they filed a writ application.
Writ application will not revive the dealership.
One thing, if your lordship trust
termination
me,
is
your lordship
continuing.
will kindly say, based annexure 1, writ appeal. In the writ appeal, Indian Oil Corporation says, as per our records, Sri Jitesh Chandra Bag, it is in on Miller's.
Have they recalled the termination letter?
And 1911-2018, they say, as per our records, Sri Jitesh Chandra Bag is one of the partner of the RO dealership. This is for kind information.
Well, it does not say that it was not terminated. The question is whether on the day when the dealership was granted against paper,
Yes.
this dealership was continuing or not? No, part of 2000.
But it does continue. Our submission, what?
Say it was terminated.
Terminated, but they filed the writ application, it was restored. One of the partner filed the writ application.
Where is that?
I have not filed it. Your lordship may keep it to some other day, I will file it. I have not filed that order.
You are appearing to whom, madam?
He is
My lord,
appealing
I am
for-
appearing for the, my lord, the sole respondent, my lord. The-
Sole respondent.
Yes.
So, what is the position according to factual?
My factual position is that termination was in 2011. Status quo order was passed, my lord. Thereafter,
When was the status quo order passed?
in 2012, my lord, I have brought the order, my lord.
So whether that status quo was status quo ante or?
No, my lord, simple status.
Termination is continuing.
Do you have a copy of this status quo? These are basic foundational facts.
Final order. Final order copy I have. The status. Final order copy I have.
Final order in the writ petition?
Yes.
What is the final order?
2000. Petitioners in this petition have prayed for following prayer.
What is the conclusion? What is the
Conclusion minutes, the writ petition is disposed of, interim order stands vacated.
Date ta kohu nanti? Date ta achi pura?
Date 16/11/2019.
Interim order stands vacated, ultimately last.
Interim order is dated 31/1/2011. Yes, sir.
Give us the order. Please give us. We want to see.
I'll get them.
Lot will depend on that.
Acha, wait.
That writ application copy has come, my lord.
Let us know, there'll be stay. There'll be stay of the order dated 31/1.
Yes, I know. I think because 31/1/11 is the, has been stayed by this court for 8 years back.
When did they inform you that the relationship is still complicated?
2018. By email they communicated. I have filed on 9/8/2018, page 23 minutes. Indian Oil communicated he is continuing as a partner.
Dealership is continuing now.
Unless the dealership will be continuing with the, why should they say he is continuing as a partner?
1/7/2000 order was not applied was also expected as the- in that respect.
That's the communication says, as per our records, Jitesh Chandra Bagh is one of the partner of Aro dealership. This is for your kind information.
Contempt proceedings. No separate contempt proceeding is necessary. This is the factor in this case. Others will be effective.
You are mass and Tosi feeling.
Mass Santoshi feeling.
No,
This is not Mass Santoshi.
Which company? Somewhere Ranjan Meg was.
That was the earlier one.
he was the other partner. He was the other partner in my husband's farm.
Jitesh Chandra Bagh and Soumya Meg.
My husband's name is Jitesh Chandra Bagh. Soumya Ranjan Meg has written a letter to them. On basis of that, they are now.
Too technical.
Let's keep it to next week. I'll give the details.
Technical. Because there was some
No.
then on the ground that
He was not very good.
Take it.
Madam.
Athlete been directed to proceed pursuant to the letter of intent dated 8/1/2017 in respect of this dealership for
Mr. Pal,
Madam.
what is this dealership described as?
Madam.
What is the dealership described as?
My dealership. The retail outlet at my lord has not been named yet because it is now being operated by them. I have not still opened it. The
Did you
retail,
file the writ petition saying what?
the retail outlet at Bolangir, my lord. This is my lord, they say the MS and HSD retail outlet dealership at location Bolangir town on
what-
Palace Road, National Highway 26 within the municipal limits.
So MS is
Three
motor
A,
spirit and
Yes.
high speed diesel.
High speed diesel and motor spirit, my lord.
The advertised location is Bolangir town, my lord, on
Yes, yes.
Palace Road.
which are the on it. And for this dealership. LOI was issued.
Yes, my lord. It was issued and then it was kept in abeyance.
Then it complaints were received, then it was, then she was noticed and then.
That the respondents was a partner in a firm running a retail outlet under Indian Oil Corporation. Limited, LOI was kept in abeyance. This was background law. For the
see. Where is that kindly should not
It's
have
annexure A by 1.
annexure?
Annexure 1 means A by 1. Counter affidavit, annexure A by 1. Yes, read petition. I will give the.
Page 96, 94.
Page 94 of the multiple dealership. Page 94, that is there.
Share for selection. Dealers for regular and regular outlets issued by three companies with the Indian Oil, Father Petroleum, Cross Capital A. This Roman 1, of which reads the was specifically taken in the challenging the action of Admiralty in keeping the employee in arrears responded by the number 18496 of 2021. Was taken on behalf of by the respondent that respondent's husband has already resigned from the partner of the ship of not in dispute that one of the partners was running retail outlet at Noapada. Not in dispute that the for retail outlet at Noapada under IUCL was terminated on 1/1/2011. One of the partners had challenged the order of termination of dealership by filing a petition giving rise to WPC number 4187 of 2011. In the civil petition, an order of stay was passed on which date?
23/2/2011.
31/1/2011.
Huh?
Stay order was passed.
Stay order.
31/1/2011.
23.
No, sorry, 23.
23/2.
23/2011.
23/2/2011.
Petition. WPC number 4187 of 2011. Later disposed of, finally disposed of by an order dated 6/11/2019, which keeps us from is, council, Mr. S.D. Das, consider council. On behalf of the applicant has submitted that it is evident from this court's order dated 16/11/2019, passed in WPC number 4187 of 2011. And the dealership for auto at Mohapara was surviving in that force sent off an interim order was on 23/2/2009. Now, we have further submitted that agreement between IOCL and for termination of partnership.
Partnership deed, there was a partnership.
Termination of partnership.
Yes, I have filed that partnership deed.
So not IOCL, it is IBP.
No, IOCL.
IB.
IOCL. Indian Oil
IBP.
Corporation.
So that agreements on record in WPC 4187 of 2011. IBP.
That was earlier IBPC, then IOC.
Agreement was with IBC.
Yes, yes, your lordship is correct.
Agreement minutes I have filed. I am just giving this. That agreement I have filed it. That is a partnership deed.
Unregistered partnership deed, right?
Yes.
Unregistered.
That was a partnership deed. Responded to the and other partners who were other partner, namely Soumyaranjan Meg, other partners including Soumyaranjan Meg, the petitioners in the WPC number 4187 of 2011 was 11 of which read that premature resolution that in case of death of partner shall be done with the prior or written consent of the oil company. Has submitted that upon information received from IUCL.
First file IBP. Earlier it was
IBP.
known as Indo-Burma Petroleum.
Yes, yes.
Was one of the partners of dealership. Completed information on 7/8/2000.
I may be pardoned, my lord. That letter that was, they have written on 18th, 2018, but the printing, your lordship says 11/1/2022, they have received this. That
No.
print, there is no
The
letter.
letter they are relying upon
Yes,
from
ma'am.
the IOCL.
Yes, ma'am. IOCL has not given any date. That is, there is no date. That is the letter given by the person, their person. It is a BPSL letter. That is, say, they have asked for the information on 18th August 7th. But the information they have received, there is no date.
It is 19/8, my lord. It has not been printed actually.
So not printed, then how can you have the date?
Your lordship may record my submission. I am not 19/8, 2008.
Received on 19/8.
Yes, ma'am. It's an email.
Oh, email. Email that must be there.
Leadership of wanted this case that after termination,
No, before that.
Before termination, I had given a yes, sir.
termination, wanted husband had already resigned from partnership.
That also, my lord, they have filed the document that is also there. The termination letter that finds place in the termination letter that I have given resignation.
Was not there. Registered partnership it was not available at the time of the decision of the applicant. Keep LOI in abeyance. Stop. Next. The peculiar facts or circumstances as noted above. Based on noted above, we are not inclined to keep that. Or asked by the grounds taken down for the action.
Yes, they have filed the document. Your lordship, see page 36 of the writ appeal. Of the writ appeal, third paragraph.
36.
Meanwhile, Sri Jitesh Chandra Bagh tendered his generation by letter number 77/2010.
Your lordship may kindly read the form. There are two dates here. If that becomes the question, he himself has said, in 2008, I have resigned. Here is another date. He has himself said, in 2008, I have resigned.
No, because Mr. Das, that writ petition is not before you. The writ petition which has been filed by his partner partner has
But
stated that my partner has resigned.
Yes.
Your lordship may kindly, this para, your lordship may kindly hear. Your replies are not satisfactory. You have not. Meanwhile, Sri Jitesh Chandra Bagh.
That is paragraph.
This one, huh?
There is a mention in the writ petition.
Yes.
In which that my partner has resigned. That is why I want to take some other partner, some other person. So that is one of the reasons for cancellation.
But
No, you can't be blamed because you got those documents. On basis of that, you have revoked.
Yes.
You're right.
Item 50.
Now some SLP pending in the Supreme Court, so they want it in October.
Similar matter pending before Honorable Appeals Court and Honorable Appeals Court stay. This is regarding the purchase employees pension matter.
So when are the matter comes for 1410 date was.
Tuesday. Any interim orders? No.
Yes, yes, there is an interim order in my case, interim order to continue.
Item 57.
Academic matters. Academic matters.
Your Lordship, this is a tender matter. May I take your Lordships to the impugn order? Which your Lordships will find at page 162. Your Lordship, this is a tender which was floated by Odisha State Beverage Corporation. It is basically about. Your Lordship, may I just read that impugn order, page 162. Inviting reference to the subject cited above.
Page 162.
162.
Yes.
Your Lordships. Inviting reference to a subject cited above, I am directed to inform you that the technical bid submitted by you was evaluated and it was found that the documents submitted by you are in the name of two different trade names and are mismatching. Now, your Lordships, the bidder here is a proprietorship. So proprietorship is not a legal entity like a company or a partnership. Basically, it's a natural person whose name everything is there, and he maybe to carry his business takes up certain trade names. So therefore, your Lordships, all the GST, the PAN or licenses, everything mostly gets issued in the name of that natural person, and then he uses it for various trade. So your Lordships, the discrepancy that they found is that why in your GSTN number, Abhishek Patnaik is written, but two trade names are written. Now,
You must have GST number in the name of it.
no, your Lordships, unless it is not a company, sole proprietorship is not a juristic person. It can't be issued in the name of these trade names. It has to be on the name of the natural person. So also, your Lordships, when that person files his balance sheet or ITR returns, it is on the name of that person. Yes, what happens is the earnings from these various trade names, only reason, your Lordship. May I just demonstrate page 26, if your Lordships will look at.
Yes.
The 7. The bidder should be registered under the Income Tax Act, GST Act.
You are reading?
7, clause 7, page 26 is part of the tender call document. Under the eligibility criteria, may I take your Lordships first to page 25, the first serial number first.
Financial bid covering letter.
You'll also eligibility criteria. Page 25.
Page 25.
55 is our running page 53.
Yes, in case the bidder is not a proprietorship concern, then he should be registered under appropriate authority, like a company under Companies Act or an Indian partnership, Indian Trust Act, society and
Just a
limited
minute.
partnership.
In case the bidder is not a proprietorship firm, so this is a proprietorship.
Yes, the reason why I showed this is that juristic personality is only given to these kind of bodies, not to a proprietorship firm, and they are well aware of it. Now you'll also look at serial number 7, which comes at the following page, page 26.
Clause is ridiculous. It's not. If it is a proprietorship firm, then it should not be registered.
No, because there is no registering of a proprietorship firm.
Okay, okay, yeah, correct. Yes.
Now, your lordships, the bidder should be registered, serial number 7, under the Income Tax Act, GST Act, and also registered under the labor laws such as Odisha Shop Commercial Establishment Act, Contract Labor and ESI Act. So these certificates I have to give.
So all this you have in your own name.
Now your lordships will look at, I'll just demonstrate the document, page 66. 66.
So what is your name?
Your lordships, it's all registered name of Abhishek Patnaik, who is the proprietor.
Question of registered. You are Abhishek Patnaik.
I'm Abhishek Patnaik. I applied the tender in the name of Mahalakshmi Drugs.
Therefore, we will put this question. That what is your name?
The bidder is Mahalakshmi Drugs. Your lordships, I'm sure that
Mahalakshmi cannot be there.
your lordships may just look at the bidding document in which we have applied.
No, how can you? You could have applied in your name.
Your lordships, look at page 41. That's what I have applied. Mahalakshmi Drugs, name and designation, Abhishek Patnaik, proprietor.
Who is Mahalakshmi?
Your lordship, in a proprietorship, we just adopt a name. Like, your lordship, may I just give an example? A shop is given a name.
We understand that.
Yes,
But
your
whether
lordship.
in the name of that shop, you can get these things. Whether in the name of Mahalakshmi Drugs, you could get GST number. No.
It will always be in the name of the natural person only.
Yes. You could have applied in your own name.
Your lordships will see, it really does not make a difference.
No, it's not a difference.
Your lordships will kindly bear with me for a minute. Here, even if Mahalakshmi Drugs Angul has been written, the proprietor has been pointed out, and the same thing reflects in all the document as well. The same thing reflects in all the documents as well. So there is no discrepancy. Page 66, just your lordships may just look at. Before that, your lordships may just look at page 56. 56. Technical bid, your lordships.
Why page 66 or
56, 56.
56.
Name and present address of the bidder, Abhishek Patnaik. Everything given. Status is proprietorship. Now your lordships will look at page 66. Which is the GST and PAN number. Your lordships, after it's reflected, the legal name is Abhishek Patnaik. That means that is the person who's holding it. And I'm allowed to use it with these two trade names also.
Yes.
Similarly, your lordships will find page 67. It's a provident fund code number. To Abhishek Patnaik, proprietor of both Mahalakshmi Builders as well as Mahalakshmi Drugs. Because the same person has two names over there. He's running two businesses. Then your lordships will also see page 105.
Is that where are you showing?
That's the cause. That's the cause. They say, as because it is showing Mahalakshmi builders as well, Mahalakshmi drugs, therefore there is a mismatch. It's an additional information at the worst case, I would say. That's the cause that they had given us. Now, your lordships, very strangely, what happens is, in this tender call notice, first the technical bid had to be scrutinized and then the financial bid should be opened. They first open the financial bid and then they open the technical bid. So after having known that I am actually the lowest bidder, they find out this is a reason to somehow put me out of the race. That's one aspect. It's only I would only say it's additional. Now, your lordship, if I have to look at their counter, which your lordships will find from page 164 onwards. They come up with some additional reasons which was never communicated to us when the technical bid was rejected. And we've also filed a rejoinder. Para 6, your lordships. That it is most respectfully submitted, the petitioner, while submitting the bid, did not produce the EPF registration certificate along the technical bid. But it is there, your lordship. We have just shown that. And submitted the same at the opening of the technical bid, which was in violation of tender condition.
Please come to paragraph 7.
Yes. Paragraph 7, same thing, your lordship, which I have just shown. That it is most respectfully submitted during the evaluation of technical bid, the following discrepancies were found. The petitioner has applied in the tender in the trade name of Mahalakshmi Drugs, because I've shown Mahalakshmi Drugs.
No, your name is Mahalakshmi Drugs and Mahalakshmi and let's say Mahalakshmi Builders and Mahalakshmi Drugs.
No, I have a Mahalakshmi Drugs running. I have a business running under the name of Mahalakshmi Drugs, and I also have a business.
The business is already named. But what was the description given in your GST?
Both are reflecting, your lordships.
Both, see, difference Amba and Sons. And you say in one of the Amba, or you say Sons. So these are two things. Amba and Sons will have to combine.
Your lordships will the word is and over there.
Therefore,
so both are separate, your
you
lordships.
have to mention both, not only one.
Your lordships, but I have the reason being, because this was something to do with making those kind of supplies, that Mahalakshmi, the work which Mahalakshmi Drug does, its experience certificate matters here.
What is important is the name. Name which is a can you say that Mahalakshmi, only Mahalakshmi will say only drugs and then builders and Mahalakshmi Drugs.
Your lordships, look at it is given to both, your lordships. I'm using it for both. Abhishek Patnaik is, your lordships, I'm using it for both. Abhishek Patnaik is the proprietor in whose name all the documents have been issued. And Abhishek Patnaik also has been shown as the proprietor in the tender call notice. And the PAN number is 1. None of these Mahalakshmi Drugs or Mahalakshmi Builder can have a PAN or a GST and anything in their name, because it is not a juristic person at all. These are trade names at the best, shop names. And one of the shop names, Experience, has been shown here.
Okay, can you demonstrate from that certificate if you were saying that that was for two different business the things?
Yes, your lordship, that's there. That's there on the face of it. Your lordship, we look at 66. The word is used and, your lordships.
Yes. So and so and this. See, and is also a name, part of the name.
Your lordships.
And is part of the name of that proprietorship. Whatever.
So let me, your lordship.
No,
Your lordships.
What you are saying that since you can't get those numbers for your trade name, you got it for Abhishek Patnaik. But the trade name also you have not mentioned properly. Half of it has been mentioned. Isn't there a mismatch regarding the trade name?
Your lordship, what probably lordship said. Because if you message target, it's 8 messages. That's the reason. 80 messages. Your Lordships will anyways look at this aspect. Your Lordships will anyways also look at this, Your Lordships, from another point of view, that ultimately, at page 56, the bidder has been shown to be an Abhishek Patnaik. Name and present address, the bidder has been shown as Abhishek Patnaik. And documents are in the name of Abhishek Patnaik.
Which page?
Page 56, the bidding document. Name and present address of the bidder. It's only Abhishek Patnaik. And all the documents are also there in the name of Abhishek Patnaik. There is no mismatch here, Lordship. The bidder is Abhishek Patnaik. Document is the name of Abhishek Patnaik. They need not go into trade name at all.
Therefore, they are putting this question, whether trade name was required to be given.
Your Lordship, that's what I'm trying to say here, that Your Lordships, GSTN and all these forms, they come in their own forms. I cannot dictate that how the government is going to issue. What I'm trying to say is this, in the bidding document, the name of the bidder is Abhishek Patnaik. And in all the documents that are given, that Abhishek Patnaik's name finds place. In the second column, what has been written loses its relevance. Because if the bidder's name is Abhishek Patnaik and my document shows Abhishek Patnaik, for example, Your Lordships will be page 105. The ITR return.
There is a mismatch. We are just trying to understand the issue. Are they saying that because of this mismatch, your technical bid or individual not to be?
Yes, Your Lordship. That is in para 7. That's what they've said.
Para 7, yes.
That's what they said. So that's actually not. I mean, the information that you require for me to qualify in the bid is there before you. So that's the ultimate test, Your Lordship. Litmus test is whether I satisfy the requirements at para 7 of the bidding document, and I do.
What is page 71? So that document also you have given.
Yes, Your Lordship, you've given. But prior to that also, Your Lordship, this is also there.
Some most are in the name of Abhishek Patnaik, some in Mahalakshmi Trust.
Your Lordship will see page 105. That, Your Lordship, that will be more clarificatory in nature. We had to give our ID return. It's the name of Abhishek Patnaik.
Yes.
Page 75 also. Your Lordship.
State or
I appeal for the opposite party number 4,
Who's
who is the
that?
highest bidder.
I am
And the
appearing for the
referent appears
corporation, my lord.
corporation.
corporation?
I am appearing for the corporation, my lord. So before your lordship goes to the merit of the case.
Why did you open the financial bid first?
No, that is a wrong statement, my lord. That is a wrong, incorrect. Your lordship may see the prayer in the writ petition, my lord. No, that is very important, my lord.
Did you open the financial bid first?
No, my lord.
Have you stated in a counter affidavit
No, I have
that you have
not.
not opened?
I have not, your lordship may see, my lord.
Your counter affidavit, show where you have written.
How do you know the financial bid was first opened? The financial bid.
Your lordship may say page 161, my lord. They are documents. That is the letter, my lord, issued to the successful bidders. That is only after the technical bid was opened and it was evaluated. That date is 2/2/23, sorry, 2/3/23. 23, Annexure 5, my lord. That was the post, page 161. That is 2/3/2023, where was the information was given to the successful bidders that the financial bid will be opened on such date.
Technical bid was already rejected.
Already, by that time, already rejected, my lord.
Already rejected.
Already rejected.
Where is that?
That, my lord,
That is the list of eligible.
that is, there is a mistake, my lord, that on 14/3/2023, this cancellation letter was issued to the petitioner, my lord. But corporation has not, only corporation was under a bona fide belief that the only this information is only the person who will be successful in the technical bidding, they are to be intimated. So that was why no letter was issued to him, and in Annexure 5 was wrongly issued to all the bidders also. It has been issued to him also, my lord. But subsequently, my lord, on 14th, my lord, on that date, Annexure 5 is the letter issued to all successful bidders after the technical bid was opened.
So that letter was issued to
Him also, my lord. That was a mistake, my lord.
that was a mistake.
That was a mistake. I want to say that, my lord, before financial bid was opened, technical bid was already evaluated. That is the evidence, my lord.
That is stated.
And on 14/3/2023, my lord, the financial bid was opened. So that was a wrong statement she is making, my lord.
He is making correct statement.
My-
You are admitting this.
No, that is there. But the submission that the technical bid was opened after the opening of the financial bid is incorrect.
So he was, according to us, he was communicated was communicated
My lord,
that he was successful in the technical bid.
that was a wrong, my lord. My lord. And subsequent, your lordship may see the prayer in the writ petition, my lord.
Yes.
My lord, page 18. In the circumstances, it is therefore prayed that your lordship would graciously be pleased to issue rule calling upon opposite party authorities to show cause as to why the impugned rejection of the bid of the petitioner by letter dated 14/3/2023 in annexure series issued by the opposite party number 3 shall not be quashed. Then the second, my lord, to direct the opposite party authorities to reconsider the bid of the petitioner. So prayer is to reconsider the technical bid. Now your lordship may next turn to, my lord, page my lord 22. This tender was for 2 years with effect from 1/4/23 to 31/3/2025. By interim order, my lord, 18 months have already gone. So now only 6 months are left out,
So let that go.
my lord.
Let that also be completed.
That 6 months, my lord, only question is that suppose your lordship allows the writ petition, my lord. No, there is,
That you are doing it deliberately.
no, not deliberately, man. It was a mistake on the part of the corporation, I admit, my lord. But the question is, my lord, if supposing your
Mistake on
lordship,
part of the
with
petitioner also.
respectfully, my lord, if your lordship allows that issuing that letter, my lord.
And what was his mistake?
Mistake is, my lord, all mismatch of documents I have explained to your lordship. Your lordship may see, my lord. My lord,
That is the answer to your sub.
my lord.
All documents are available.
So I am appearing.
No, your lordship may see, my lord.
Party number 4. I am appearing for opposite party number 4, my lord. Here, my lord, the tender was for loading and unloading of alcoholic beverages, my lord. And the GST number was given, my lord. In
That
the
has been unloaded. Loaded also.
no, my lord, it's not there. Unfortunately, my lord,
That was a
if your lordship
provisional-
would take up, if your lordship would take up the counter, which my learned friend for the corporation.
Therefore, whatever reason that has been loaded and unloaded for last 18 months.
It has, that has been done at the by the corporation, lord, not by any of the contractors, because this particular contract was not worked out.
Even the petitioner is not getting.
No, my lord. There was a stay.
Other litigation also arising out of the same tender, so I'm not the only one.
No, now, my lord, what has
And
happened, my lord?
out of the other challenges, my lord, what has happened, my lord? She has, my learned friend, the client, my lord, has given a GST, my lords. If your lordship would kindly take up the counter, which my learned friend for the corporation has filed, my lords. The entire GST registration was only for goods, not for services.
That is not included.
And what has happened, my lord? My learned friend gave a provisional GST number. So the corporation wanted to find out whether a final GST number was given. Because as your lordship knows, those people who were there in the VAT regime migrated on 1/7/2017 to the GST. So this provisional number was given till December.
There is the rejection of technical bit.
On what ground?
No, what has happened, Lord, this may not have been the ground, but from the counter, my lord, so far as I am concerned, Lord, not so far as the opposite party number 4 is concerned, he can't be privy to the rejection. But prima facie, if your lordship would kindly take up the counter, the GST registration is only for goods, for sale of goods. If your lordship would kindly take up the counter, internal page, my lords, 22, my lords. Internal page 22 of the counter filed by the opposite party number 2 and 3, my lords.
That is what my submission is, my lord. My lord, we will go for fresh tender.
Cancel this and issue.
My lord.
Well, reasons, how can you give after cancelling? How can you give the reasons for rejecting the bid?
My lord.
And now you can. There is also.
My lord.
No, your lordship may kindly for a moment take up this page 22. Since
my lord.
This 6 months, no, 6 months is in no one's interest, neither for the petitioner nor for me, my lords. It's in no one's interest. So better will be, the recourse will be your lordship's suggestion, my lords.
No.
To cancel it and
No, that is my instruction is that corporation is ready to go for this, my lord. Fresh tender. My lord. Interim order is, my lord, dated
Interim order is not that you cannot cancel the tender.
17/3/2023.
So there is nothing against fresh.
My
This,
lord.
this will not be finalized.
My
Take instructions.
My lord.
2 and 3.
My lord.
Yes, sir. Yes.
So 6 months, my lord, is hardly any technically, economically viable for any of the parties. My lord. Lordship keeping it to
interim order stands vacated. My lord.
Real losses may extend the interim order. They have to come up with the
Interim order makes no difference.
No,
But that is as regards
interim order
this
does not
tender.
make any difference for them taking their decision. So let it be extended.
No.
What? If it is extended,
It will be problematic, my lord. Once it is extended, my lord.
Next week,
My lord. My lord. Oblige.
24th.
Your lordship may call it on my lord.
24th.
24th, my lord. Oblige. My lord.
So let my learned friend file an affidavit.
We will file affidavit. Oblige.
Item 68.
Item 68, Your Lordship, I only pay for next week, any day, Your Lordship, because there is some personal difficulty of Mr. Paddy, there's a bereavement in his family. So, if my lord may kindly fix this matter to any day next week, maybe 25th.
It's about that additional,
Is a performance security and additional performance security, the difference.
security demanded on the basis of a clause. Two clause has been same, two clause has been uploaded. We say this is not permissible, and they admit in the counter that there is a error, inadvertent error in uploading that.
No, that is to be explained.
Yes, ma'am.
I've got all the documents, I will explain it. Your Lordship, kindly allow me 7-8 days time so that you can dispose of.
Fix it.
CGC. Your opposite
My lord,
party?
CG.
You.
My learned friend is appearing, my learned senior is appearing for the petitioner. I am for the opposite party. Railway. My lord. His mother expired.
I was asking
That
from
two-
whom are you appearing?
For all the opposite
2
parties.
PM because the work has been stopped. That same at Man.
Two.
Obliged. Lord.
Real attitude. The Dijama mentioned that.
Item 61. Item 60.
That's 60.
Item 72.
For, yes, come. Asunto mention karkene Asunto, there's another council waiting for 73.
May I please, my lord, I have solved the copy on the AICT advocate, Vikas Jana. Sri Vikas Jana, advocate for AICT, I have solved the copy. It is for amendment, my lord. There are some letters issued from the AICT. That commercialization.
72.
My lord, my petition for amendment is there in my lord. Page 9. Yes, ma'am. This is the letter of All India Council of.
This I have been filed. There is a prayer.
Prayer is to grant NOC for admission in the.
Please wait. This I has been filed for adding the All India Council of Technical Education, bracket AICT, as a made necessary party. What it has to be opposite party. What necessary party you write in the prayer?
Necessary opposite party.
Opposite party number so and so.
Like it. Yes, it is. It is mentioned, madam. Opponent party.
Where have you mentioned?
Yes, madam.
Look at your prayer. Where have you mentioned?
My lord, proposed amendment is there.
Petition and to add paragraph 7 and 8, which have been mentioned in the schedule to the IA. To the IA. We have heard the counsel for the petitioner and the counsel for the opposite parties. We are satisfied that the amendment should be allowed. The IA is accordingly allowed. The petitioner shall file the consolidated writ petition by incorporating the said amendments by when?
Tomorrow.
By tomorrow. By 18/9/2024.
Yes, ma'am.
This is the case on 24/9/2024. Agunoch. Something else you were saying?
After filing the consolidated petition, this will be had.
Yes. The consolidated petition if filed as undertaken shall be scanned and incorporated in the digital report. Extra declaration.
73.
My lord, in the NEET UG examination, the petitioner's OMR answer sheet has been wrongly evaluated and 5 marks has been deducted. While the petitioner is entitled to 644 marks.
It's urgent because one there appears to be some not clear. One question, other was clear.
I have already communicated.
Counter has been filed in this case, madam.
So what have you stated in your counter?
My lord,
What is the counter?
my lord, the candidate has scored 11, 11 questions out of 15 questions in section B, my lord. So as per the instruction, he has to only fill up only 10 questions. He has to appear in 10 questions. So he has, out of 15, he has to appear, he has to give 10 questions in out of 15.
He has answered 11.
He has answered 11. And in one question, he has answered both the questions, both options, my lord. So that question was marked as wrong, and the last question was not considered by the NIT.
My lord, in the
NTA, sorry.
in the examination system, there is whenever original answer sheet is lies with the opposite part number 2 along with a carbon copy. From the carbon copy, it can be evident that the petition. My lord, I have filed an IA to call for the original OMR answer sheet along with the carbon copy. From that, it can be evident that whether the petitioner has made attempt that question.
So you're disputing.
No, my
You're
lord.
disputing that you have not answered 11 questions instead of 10.
No, I have answered 10 questions only.
So you're disputing the correctness of that
My lord.
Xerox copy.
My lord. My lord, they have kindly see, they have filed the Xerox copy. Kindly see page 18. Question number 148. I have not attempted it.
Page? Page.
Page, my lord, counter page 18.
Yes.
My lord, I have answered question number 149, 10 questions. But they have taken 148 as attempted. And
the point which he is taking has been taken in the counter.
My lord.
Paragraph.
My lord, they are saying in the
Para
counter.
18, para 18.
Para 18 of your counter.
My lord. Page 12, my lord. We have given a sheet of responses by the petitioner, by the candidates.
No, in your affidavit, where have you stated?
In para 18, my lord, page 12. May I read, my lord?
Yes.
That as per the record maintained by the NTA, the petitioner herein, that is Shubham Kumar Chand, has attempted 163 questions correctly and 13 questions incorrectly. As per the scheme of the examination, he has been awarded 4 marks, 4 of each correct answer, and 1 marks has been deducted for every wrong answer. Accordingly, he has been awarded 639 marks, that is 163 into 4 minus 13 into 1 out of 720. It is further relevant to, my lord, I'm skipping that annexure, my lord. Then it is further relevant to mention that the petitioner has attempted more than 10 questions in section B from question number 36 to 50. And as per the predefined and pre-declared scheme of the examination, he has been evaluated for the following 10 questions, my lord. So 36 was correct, 37, sorry, my lord, 36 was wrong, 37 was correct, but in 38 he has answered 2 options. So that was considered to be incorrect. And from 39,
as per your
no,
scheme,
so 30, sorry, no,
so as per your scheme, you'll take the first 10.
first 10 of out of it. So 39 was marked as 1 and 2. So that was incorrect, my lord. And then
No, first 10, because they can't select.
My lord, I have answered only 10 questions. 148 I have not attempted.
You'll just missed out item 60, which was called out. But anyways, it will take me a little substantial time. Can it be called in the first 5 you wrote? Item 60 here.
No, what is it about?
It's about the mining lease matter. It's urgent because of the fact that Now, the reason is urgency. If your lordship, the urgency is being that actually his mining lease should extend to 2030. And the prolonging of the matter is eating into the time, your lordship. That's the, your lordship, that's the only reason we are insisting. If your lordship will accommodate us tomorrow. That's tomorrow. Yes. If your lordship can fix a date, otherwise if I.
So it will come tomorrow.
Tomorrow probably your lordship may have that single venue.
Therefore, whenever the matter is listed, the matter will not go out of. Become listed in the date.
Yes.
Spread
All
over.
the matters shall be listed on Monday.
Spread over.
One matter item 54, that your lordship are dictating that order, that your lordship may remember that Bolangir and that Keonjhar district. Yes. So
My lord, item 67, my lord.
Lord, item 60.
Well, that I am just item 54. Yes, that's.
Lord, item 67, my lord.
I'm
Item 67, my lord.
Face admin tomorrow, lordship. Rest of face admin.
Lord, item 60.
28 lordship. Noted face admission matter. But otherwise.
Item 61, my lord, interim order is to be extended, my lord. 61, my lord, 61, not.
My lord, item 60.
My lord, may I
Item
request?
65, my lord, but the state has already filed a counter admitting the petitioner's case. Can be taken up any day, it will be. Oh. Yes.
My lord,
Who is for the estate?
Mr. Mahanti, 65, who's brief? Vasudev Panigrahi.
It has been admitted to the counter affidavit. Then why does he need any order from the court?
Suman Patnaik.
Whosoever is there, if the claim has been admitted, just proceed by order.
Because of his pendency, my lord.
Yes.
Item 67 may be taken day after tomorrow at 2 p.m. my lord. This is related to the stipend of the students. They are continue.
It is impossible. Make a mention on Monday.
No, may I just request towards
an admission matter,
Admission
to the college that has been stopped despite your lordship's detailed judgment.
which court?
This is Sivanand, this is technical education.
Which court?
This is the PDIS, that is the which your lordship is the skill development and technical education department. Because this your lordship passed a detailed judgment. A 23-page judgment was passed deprecating their action of non-assigning of any reasons why the admission should be stopped. Despite that, they still, despite your lordship's judgment, they have gone ahead and then again stopped taking admissions. So therefore, Millets, today Millets, this department, skill development and technical education department.
Tomorrow, let it come.
Lord's
Item 39. Say,
Well, may I just mention this in
the
the
lordship judgment was NGT order has been stayed in a writ. NGT order, final order of the NGT has been stayed in a writ. I am for the opposite party, my vocation of stay of 5.
That is interim order.
Yes,
That is listed for orders. Which item?
Item 39. Your lordship has already covered it by.
Item
Yes, 22, section 22 appeal is there to Supreme Court. Your lordship has already held. So the writ has been filed directly questioning.
Item 52, my lord. Item 50.
All matter will come Monday and Tuesday.
Lord, may I just request your lordships to have the matter of item 26. Lord, Lord, may have it on 25th of this matter, on the 25th, Lord.
Item
26.
26. I'm for the petitioner in this matter. There is something urgent has to be done because the Lordship has not passed any order of.
26th to the other.
I have it on 25th.
It will come on Tuesday, Monday or Tuesday. Make a mention on Monday.
All right. Let's go.